Pass on the memos. Please pass on the memos. Please pass it. Why the seniors are mentioning? This is what the juniors.
Under a very compelling
Let the juniors mention the matter. Why the seniors?
review application.
Oh, it's true, sir. Pass on the memo. We'll do it. Don't
Then director has to seek your leave so that they can.
Oh, we'll take care. For that, why the seniors will come? Send your junior.
The registered Odisha High Court in the petition. That is the reason. All are there.
So what? So what?
We are giving the.
Please.
Rather to mention your lordship, it is a matter related to the.
Give.
Yes, sir.
Please give. Don't worry. Yes.
For judgment item number 1, W 526 of 2025.
The appeal is allowed. All pending interlocutory applications stand disposed of. No order has to pass. Yes. Call another matter. Pass on, don't mention.
Precedence in item number 2.
You have to read for this paragraphs. No answer.
Item number 2.
Lordship, I am virtual mode, my lord. I kneel there for my apology.
What for?
My lord, I am for the petition, but I am ill. I was hospitalized and 2 days back I was.
So why apology? So this is a
virtual mode I am appearing, therefore I am taking apology.
why the virtual mode we are accepting it. So why
So,
apology?
my lord, but some judges are saying that you should
It's
appear
our
in
pleasure
court.
to hear you on a virtual mode. Where is the difficulty?
Yes, my lord. I am the petitioner for the appearing for the junior degree engineers. I have challenged the HARISH of the junior engineer rules 2012. State has not filed counter.
Is a central rule or a state rule?
State rule.
And the Advocate General is required to be noticed.
Notice that last time it was directed for instruction. State has not filed any counter. Meanwhile,
Is the Advocate General? Oh, the Advocate General has been.
Advocate General, we have also got a paradise committee lordship. We'll be filing a counter. It will come after 4 weeks.
This is challenging what? The virus.
Challenge
Yes.
HARISH of the junior engineer rules 2012. Page 22, my lord.
The entry point, your lordship, the major challenge is that why the BEd graduates cannot be inducted into this. Inducted into the service where the diplomas are allowed, your lordship. Because this is at a lower hierarchy, your lordship, the entry level of.
I think there is a Supreme Court judgment on that which says that the BEd cannot be the criteria for elementary education. That was that originated, I think, from Andhra or somewhere else, where for pre-elementary level or a primary level, the BEd was said to be a compulsory. And NCTE guidelines was also taken into considerations. That is a recent judgment of the Supreme Court.
In this case, I'm appearing for the diploma. So in case the interview, there was a similar issue pending before this court, and then it has been disposed of. Now the matter is pending before the Supreme Court. We have given those numbers.
Oh, there is already one judgment has come regarding this BEd.
This is vis-a-vis
This is
BTech.
B.Tech. This is B.Tech.
Oh, B.Tech.
BTech and diploma.
Oh, a B.Ed. I heard B.Ed. That's why.
B.Tech theology.
BTech.
BTech.
Okay,
B.Tech and
B.Tech.
diploma.
Oh, that's a bachelor in
Junior engineer,
technology.
junior engineer entry post. That.
Your Lordship may give us 4 weeks.
So the B.Tech was also included there.
It is not
They were not
exclusively
included.
meant for the diploma,
Okay.
as there are two service rules, one meant for the diploma and one meant for the.
So there are two parallel sources for some recruitment.
B.Tech, it is at a higher level, and for the diploma engineers, it is at the junior
The
engineer,
lowest.
lowest level.
And what about the promotional avenue?
Assistant engineer.
40% as I was
Assistant
discussing
engineer.
with the authority.
Assistant engineer.
Yes.
This is for the JE.
The promotional avenue, my lord.
Junior engineer.
Oh, let me understand. First thing, the source of promotion, let me understand. What is the junior engineer? What is the hierarchy of the service? Which is the just promotional post?
That is JE, then assistant engineer.
Assistant engineer. What is the qualification for the assistant engineer?
Yes, that is
Only
for B.Tech is as assistant engineer.
Assistant executive engineer.
There are two parallel mode of recruitment to the post of assistant engineer. One directly from the the recruitments and the sum as a promotional.
Yes, 40%, your Lordship, of the post.
40, 60.
40.
60 direct and 40 promotional. So diploma holder will become an assistant engineer. And what is the eligibility criteria for appointment to post of an assistant engineer? B.Tech,
B.Tech.
no diploma.
Just may I clarify?
B.Tech.
There are two rules which came in 2012. One is called the diploma service rules. In that service, there are two cadres. One is the junior engineer, the promotional assistant engineer. The entire bulk of junior engineer go to become the assistant engineer. So therefore, only the diploma people do get promoted. Then there is another service rules which is called Orissa Engineering Service, which starts with the base level post called Assistant Executive Engineer, where there are three sources of entry. One is promotional, which is from the assistant.
The feeder post is the assistant engineer, diploma holder.
Yes. And then there is a direct recruitment. And then there is a post where people have, in service, they get their degree and they also compete in the direct recruitment.
Okay.
If you get
Those who are diplomas.
I understand that those who are the diploma holder, if they admit themselves into a full-fledged degree course and then obtain the degree, then is another route for promotion. How can it be?
promotion, they have to sit for a different exam.
There must be a different cadre.
Yes.
So,
These are the three. So therefore, the diploma engineer do get direct promotion from assistant engineer at a 40 to 40% quota. But that comes after a very long service period.
so what?
That is the whole thing.
Around
And
10,
as far as the
10 to, these days it is around 10 to 15 years. Actually.
Okay, I can understand that. Point it get merged, this assistant engineer executive, the normal assistant engineer, they gets merged at one point of time further.
In the cadre of assistant executive engineer, or they come from three sources and merge in one cadre. That's the merger. So they lose their original identity. They take it as and when they enter on the basis of the date of entry.
What is that, the infused cadre?
Assistant executive engineer, which is
That is a different. Executive engineers different. Assistant engineers, those who are coming directly are different.
yes.
So all these things get merged at what stage?
Theologians. First, under the diploma service, you have junior engineer. All the junior engineers become assistant engineer.
That is the assistant engineer, no further qualification
So these
or no distinction.
Yes.
No distinction. They are the simple assistant engineer.
Simple.
Those who are directly coming under as an assistant engineer, their designation is assistant engineer executive.
No, then there is another post called assistant executive engineer above this post, above the post of assistant.
So somebody who is promoted as an assistant engineer and somebody who is directly appointed as an assistant engineer, both having a different eligibility qualification or educational qualification.
Yeah.
One is a diploma holder, another is a degree holder.
Engineer, assistant engineer does not have a source of direct recruitment.
No.
Yes.
So it's all the promotional
So therefore, assistant executive engineer
as a direct.
has a direct.
I understand. So assistant executive engineer and the assistant engineer, they get merged at assistant executive engineer post.
Yes.
Merger is there.
Yes.
Now this merger has a three multiple sources,
Yes.
if I correctly understood. One is directly, one is by promotion, and third one, those diploma holders who subsequently got the degree, they are treated differently let me understand.
Right.
This is what? And then they get infused into one cadre.
I can just say something on it.
Yes.
Here the basic question is whether a person with higher qualification can participate with a higher qualification can participate at the lower level.
I think there are certain lines where suppose for a group D staff which has a qualification of class 8, if the MBA grad or the graduate they participate into the recruitment process, will it not be an unequal the competitions?
Yes, that's precisely our
So
point.
sometimes there is a barrier which is said that those who are graduate or those who have got a postgraduate degree, they are not qualified for those posts.
But this exact matter, similar issue, is pending before the Supreme Court. So we have given a short note. Your Lordship can just have a look.
What is that matter which is pending?
So I've given the numbers.
No, not numbers. What is the subject matter?
Same degree people wanted to participate along with the diploma holders. This court, the single bench held in our favor. Writ appeal we succeeded. Thereafter, they have challenged it in the Supreme Court. And this very same.
But was held by the High Court.
Saying that you cannot encroach into the territory of the diploma. So what falls from your Lordship, that only the division bench has held. And now they have challenged it before the Supreme Court. And this very same writ petitioner was a part of those writ appeals. He has somehow not disclosed those proceedings in this writ petition.
No, then who has gone? The writ petitioners they have gone to the
The writ
Supreme Court.
applicants have gone before the
Supreme Court. Writ applicant means writ petitioners.
Writ petitioners who lost and writ appeal also they were active.
May I submit, my lord? In those cases, HARISH was not challenged.
That's correct. In those cases, virus was not challenged. So in one set of litigations, they are saying that we may be allowed to participate under the existing rules, and now they are challenging those very same rules.
Let me just.
But we are challenging HARISH.
Lord, may I be permitted? I was arguing those batch of matters. Let me. Lord, this post of junior engineer. In fact, there are two different service rules under 309. One is for recruitment of junior engineers, qualification prescribed is diploma in engineering. Other is engineering service rules, also under 309, prescribing the qualification of BTech. Look what is happening. These diploma engineers do not have any other scope to get into the engineering service. So you Lordship was rightly pointing out, if there is a higher qualified person is competing with a lower qualified, there would be unequal competition. There are so many judgments we have cited that has already been taken care of in the division bench judgment. So, Milord, in latest patent appeal, the same parties are litigating. They were challenging that no, we should be given the opportunity to participate, the degree engineers. The court has clearly held that it is within the domain of the executive to prescribe the qualification, unless it breeds discrimination, it doesn't. So therefore, those batch of engineers have already gone to Supreme Court on this same issue. So now their whole intention is to stir the recruitment process. There has been no recruitment for the last 4-5 years. So there is serious.
No, what has happened? The Supreme Court has passed any interim order
Miller,
or a simple, the notices?
simply pending. There's not really-
Is a-
Just a minute.
Is the notices issued or not?
Simply diary numbers have been.
That enough.
Then it has not been admitted under Article 136 as yet.
Same issue, Miller. The same issue. Now, Miller, their whole intention is to stall the recruitment process.
Since
There are-
when it is pending in the diary number
Miller, that is since 25th of April 2025.
or recently?
Just 3 months.
3 months time is given to remove the defects, otherwise,
That is not the issue. Issue is, Miller, that is already get division bench judgment.
that's I understand. The enmity and the committee of the judicial discipline is to be followed
Right.
unless we have a very strong dissenting views
Absolutely.
to take a depart
Right.
from the views which is already expressed by a coordinate
Absolutely.
bench. That is when the matter is already sub judice in the Supreme Court. If the Supreme Court accepts the views of the division
He
bench
say issue is same.
and dismissing the special petitions, I am conscious not a merger, but still
That's
some credence should be given to that. No, though it will not attract the merger.
No, you like Panya, Mamad and.
As 2000 volume 6 SCC or 4 SCC.
Kote distillery and Punyam.
I could never pronounce that. Pune Ahmad or something.
So that's not the issue. The issue is same. They want to be the whole, I think last 3-4 years, there was a stay on the recruitment, junior engineer and assistant executive engineer also. Not recently, I was arguing before the Supreme Court. We succeeded here, the gate examination. So the Supreme Court clearly said your intention is to stall the process. You are not interested to take part. You want
No, that is a different
So,
issue.
yes.
That's
So,
a different
yes,
issue.
We'll find a counter. Let it come. The virus is under challenge. We'll find a counter. If you also propose to hear it, we'll
Adam, this is the same issues where
Same
it
issue.
may not be
Yes.
the virus is not under challenge.
Supreme Court is already insisting
See,
over
in
the
those matters, the virus is not under
Yes.
challenge. But there is clear-cut announcement, the pronouncement of a judgment, which talks about that if the rules permits the diploma holders only to participate, then the degree holder cannot say that I have been discriminated. So in that event, let us hear the virus and we will not pass any interim order because we can't forestall the entire process. That can't be done. My brother is more
No. I will.
because he was a party to
No,
that
no, no.
judgment.
Minor case.
That is a reference note. That is policy. This is the current
Oh.
recruitment, technical services recruitment. This is before the Supreme.
Oh, this judgment of 11th March is before the Supreme Court.
Yes.
11th
My
March,
Justice
the
Raman has also been.
No, that is fishery case. That is
11th
the-
March is before the Supreme Court. And the first appellant is the petitioner here,
Here also. The same party.
same person. But he has not disclosed about the developments of that case.
Being
has it
unsuccessful
disclosed
there.
about this case in the pleading?
No.
We are the same pleading. You must.
Who is the appellant?
Compare.
But it's my friend of theirs.
Oh,
The
if
same
there is a
set-
suppression of the fact,
Petitioner, the
if
same
you
set-
were the party in that particular earlier round of litigation, will you not make a pleadings to that effect? Is it not a suppression of the material fact?
Absolutely, we are. Absolutely. Same set of lawyers, same set of party, same set of.
Sir, even if you challenge a virus, you could have pleaded that in an earlier round of litigation, since the virus was not the subject matter of challenge, then the cause of action is a different. Now we wanted to challenge the virus. Will you not plead all these things?
We are suppression on that ground, it is, we are liable to.
Why not? We will dismiss.
Mr. Mishra, what are these numbers? Have you got
Cases which are
the
pending have been disclosed,
present
but the
petition
market
copy?
was
There is
disclosed
a
by
fund
certificate.
certificate.
Appeal numbers.
this virus restriction?
Yes.
Do you have? That
Yes,
page
I
number
have.
3.
Yes,
Page number 3 here.
yes, sir. You are appearing virtually.
Those are
It
single.
appears that there is one matter which is pending before the Supreme Court. You were one of
Yes,
the party there. Why you have not disclosed those facts in this writ petition?
I will take instruction, my lord. I have no time. I
What
take
instruction? Have you not drafted? Have you not
I
settled
do
it?
not know whether the present petitioner are the appellant before the apex court or
You
not.
do not know. There's a
Because
very interesting.
that is a case pending. My lord, that is a case pending before this single judge. So far, the
Sir,
petitioners are concerned.
I am not concerned whether it is a pending or disposed of matter. I am more on a conduct of a party when he approaches the court, whether he has approached with a clean hand and also disclosed all the facts. If it appears that your client was also a party in an earlier round of litigation, if in this pleading he has not disclosed, does it not tantamount to suppression of the material facts, which
My
entitle him to any discretion to be exercised?
My humble submission would be that so far the petitioners are concerned,
First petition.
one single matter is pending before the single judge. And so
Sir,
far
this
the,
is a matter you have gone to the Supreme Court. You have gone to the
so
Supreme
far
Court.
I do not know, my daughter. I have
You
no
do not know.
instruction. Come next week, I can.
Sorry,
I have no
who's the
instruction,
advocate in
madam.
record? Why? Who has drafted?
Milord, I do not think that they are.
You were not. Are you not? Sorry, whether you were not representing the petitioner in an earlier.
No, ma'am.
Who was the advocate in record there? What is your
No,
good name?
no. I was not happy. I was not happy.
Then who was? Where is Mr. P.K. Roth? And who was he was a senior advocate. Who was a junior assisting him? Who was
I was not
assisting
the
him?
lawyer before the division bench. And I hope and believe that the petitioner are not the appellant before the apex
My
court.
lord, we are just limited to this only particular petition of Further Paris, and rest of the petitions also we are not even a party.
Sir, your client's name is Chaudhary Shobhagyo Mohandas.
Yes, my lord.
So you were the appellant there in the WA number 62 of 2025. You were the sole appellant.
One of the
It does not appear in another's or something like that or others. It's a single name which I find. So that's why I treat it as a single appellant. When you were a single appellant in WA 62, there is another WA 3433 of 2024. There are many peoples.
But their instruction was there were two types of the recruitment process. One was in 2020.
Sir, you are avoiding or are digressing from the core issue. My specific question is that if you were a party in an earlier round of litigation, will you not disclose those facts in the instant petition? And then try to distinguish that the cause of action is different, the cause of action here is different.
But they have instructed me that they were not a party. What
Then who represented them? That name is appearing WA 62 of, then we'll have to call for the records and we will find from the Wakalatnama.
We were not a party.
Yes,
We were means we are not concerned with the advocate. We are concerned with the litigant. You are simply
Yes.
representing your client. What is the role and the conduct of your client? We will dismiss on the ground of suppression. You can't take the court for a ride. And the change of advocate does not mean the change of the stand of the party. Is one and the same. Is a party who
I'll
is
check up that. I'll check up my lord. Let it come next week. I'll check
Sorry,
up
you
with
do
my
not.
client.
Your client is too smart and
Whether they are
plays with the
suppressed or
court.
not. Whether they are suppressed or not.
Playing with the court. Too smart. If he has not disclosed, then he should be penalized. Why he has not disclosed to you?
Yes, madam.
So we are going to dismiss this matter.
No, madam. Don't say keep it next week. I'd
Sorry,
like to take
the
instruction.
conduct and we are imposing a hefty cost for that.
Lord Sima, give me a chance to take instruction by my client.
What?
Let me take instruction by my client. Then next week, Lord Sima disposed of, impose conviction, whatever you
Sorry.
do. Unless your lordship get it that they have also picked up.
Come tomorrow, take instruction over the telephone, whether it was a party, WA number 2 or 2025. Tomorrow, first matter as for order. As for order.
Day after,
No, sir, tomorrow.
day after,
No, sir, tomorrow.
day after tomorrow.
No, tomorrow.
All right, all right.
Tomorrow come. Lago. In course of the hearing, with clean hands. His conduct is also relevant for the purpose of exercise of, I think, for exercise of discretion by the court.
WA number would be 62 or 2000.
I know, that is what I've seen.
Instead of 24,
No, 62
25.
or 25.
20.
So you are one of the respondents.
Yes,
You are-
in the writ appeal,
No.
here we are interviews.
Instead
Instead of respondents, it should be interviews.
Respondents/interveners.
Item number 4.
A similar matter.
Come tomorrow.
Item number 4.
Please, to draw your lordship's attention to the fact that, my lords, the entire terms, there was a head of my lord's, moral query. Your lordship may kindly come through, tender is annexure 1. It's in Oriya manner, but the mining plan will also reflect.
Tell me, sir, can a public interest litigation lies against a tender?
Well, if the loss to the state exchequer, it could.
That means what? This public interest litigation is never intended as an adversarial litigation. It is inquisitorial in nature. It is only for the public good, where the governments are reminded of their solemn duty given under the Constitution. Either the infringement of a fundamental rights under under Part 3 or a directive principles under Part 4 of the Constitution. They are simply reminded. They have to put in order rather than to go wayward. So this is what we wanted. Here you are challenging a tender. You can challenge the tender by a writ of certiorari over into or a mandamus, whatever. But
What has happened, Manoj? These are the public who have come.
maybe that's a one has to create a line of distinction.
I bow down, Manoj.
With deepest of respect, I have been noticing here, particularly the public interest litigations are coming up in a very, may I use a very bad terms for it, erratic manner.
Your Lordship, kindly bear with me, Manoj. I quite appreciate Manoj, Your Lordship's distinction. Here, Manoj, the tender was floated for 33,000 metric tons per year. Mining plan was sanctioned accordingly. The lease deed was also executed. So that was the revenue that was targeted by the government. And then after executing the lease deed, the lessee applies for a modification of the lease and reduces the amount to 3,000. My lords, instead of paying the royalty for...
So that is a personal wrong that has come. How the PIL lies. PIL means there should be something guidelines that you cannot do it. This is beyond your competence. Neither you can exercise the powers in the stateless, nor you can undermine any of the constitutional provisions. How it's a decision.
The loss to them.
Maybe.
And this is a loss to the state exchequer.
I am asking, suppose the government decided, I tell you, this hypothetically, government decided that natural resources should not be diminished. We will not permit any quarry to be done or minor minerals to be extracted. Let us go hypothetically. Can the litigant come and say that no, extract it? Sometimes the preservation for the posterity.
There it could not be permissible. Here, my lords, this is a daylight loot of government exchequers.
Sir, they cannot operate a quarry beyond the permissible limits.
Yes, my lord.
So the natural resources remained. If they were permitted to extract 33,000 and now they wanted to have a 3,000, then at least 30,000 natural resources are still there, deposited, kept.
No, that is also there. That is what I'm trying to draw your lordship's attention. Lordship may kindly come to the facts.
I was looking
only one paragraph
from 1980. I was looking all those judgments because this really troubles me. That how the PIL
just one
can be done.
I leave it to your lordship's paragraph.
From the judgments of Justice Krishna Iyers, Justice Bhagwati, until the last.
Justice SP Gupta's case is also that's the leading case.
I'm saying Justice Krishna Iyer was in 1980s. That was the first time. It's a judge made the remedy.
Right.
So it's not a
just
absolutely. The purpose and object. But these kind of if we have anything on that they cannot reduce it, then we can come and challenge that.
There's just one paragraph. Well, just one paragraph, paragraph 14. I leave it to your lordship thereafter. Lordship,
sir, first satisfy me that a PIL lies. You first satisfy me that the PIL lies. I will go by that first.
Well, then your lordship may.
Yes, I am giving you time. You come with all the line of judgments. I will also give you all the line of judgment which troubles me. You just go through it and come.
My grateful man.
Yes, from 1980, I will give you all the judgments.
But I have also read some of the judgments, Manoj. But I thought, Manoj, this is an issue where there's a loot of government exchequer, broad daylight.
I have failed to understand this. That extraction of a minor mineral.
Illegal extraction is going on.
Please, what you can say that if you have permitted up to certain ceiling limits, this is you who have to ensure that the quarry is not permitted beyond that.
That is what they are saying. Precisely, that is what they are saying in the representation. That is precisely what I have stated in the para 14 of my.
No, I understand.
Precisely, that is the issue. that you have reduced it to 3,000 from 33,000, which was an eyewash. You reduced it to 3,000. Now you are transporting 200 trucks per day. And that is what I pointed out in paragraph
200 tons.
14.
Each truck contains how much?
It should be
Maximum 10 tons or capacity of 8 to 10 tons.
But they're lifting 2,000 tons.
So they will exhaust within 10 days or 5 days.
That is exactly. And without paying, this is all smuggling money. They're all without paying the royalty. This is where and collusion of the officials is apparent.
No, to that extent we will definitely entertain. There is no difficulty.
But that is the angle at which I am pressing before your lordship. Nothing else. It is only that angle.
Do you have any evidence in this regard? Have you produced any documents?
I have the photographs now. Series
No,
of
not photographs. If they are permitted under a certain ceiling limits, you do not know that this photograph which they are transporting is within that limit. Tell me beyond.
That.
Show us. Any invoices, anything which they have done beyond that?
During a period of time, there must have been certain returns filed before the mining authorities, supported by certain.
They will not file. The returns are that is why we are praying for your lordship's intervention. The returns would be 3,000.
True.
Papers are in order.
Supported by certain
Show us the evidence. Show us the evidence that they are doing it beyond that.
But your lordship can appreciate how this is happening. The tender is floated for 33,000. So therefore, it wipes out the competition. They don't come. Rates are also very reasonable rates. So there are no bidders, virtually no bidders. One person comes and bids. 33,000, he takes the bid. He executes a lease. But once a lease is executed for 5 years, thereafter the authority is bound by the lease agreement, lease deed, and also the lessee is bound by the lease deed. And also he is bound to give certain bound with the amount of quantity of royalty to be given to the state.
Can it not be varied, modified by consent of both the parties? Law is that unilaterally you cannot vary any terms of the agreement or a contract. But if both the parties agree to vary, then is there any bar?
In a public contract, my lords, my most humble and most respectful submission would be, my lords, that in a public contract, that would be changing a paradigm shift in the contract.
This is not a paradigm shift in that sense.
What has happened? What is happening here? That if it is 3,000, tomorrow there would have been 15 bidders who would have bid at a much higher rate. Now he has bid for 33,000. Obviously, the rate is low. And then you reduce the quantum.
Show us two things. That the conditions at the time of inviting the applications in relation to 33,000 is far more stringent than the conditions which is likely to be imposed in relation to 3,000. If there is a gulf of difference, then you can say that it offends Article 14. For a reason is that you exclude certain more eligible participants, anticipated participants, and wanted to have a cherry picking of handful persons. Because had it been a 3,000, the barriers would have been more low in comparison to 33. And so that lot of more, as you understand, have you made out a case of that? Show us that what could be the barrier which they have shown for 3,000 and what is the barrier which they have shown for 33. Difference.
Rules, as I have examined the rules, there is no barrier apparent in the rules. It is in the operation of the rules that the whole thing, the prejudice comes.
No, I do not know. In a notice inviting tender, the eligibility or the suitability of the bidder is to be judged on certain parameters.
That is there.
If it is intended for 33,000, then the parameters will be more higher because it has to meet those requirements.
These rules are
is there? You just show me.
Look, these rules actually are not designed that way. It is there. Man,
Arguing something which has to be pleaded.
man, I have taken that in the representation given, man, annexure 12. Man, my averment is in para 14. Para
See
14.
the last part of the prayer. The petitioner has approved for environmental damage, violation of Forest Preservation Act, and environmental pollution.
And also to assess the total illegal extraction of minor minerals and compute the environmental compensation. Para 14. That
Can it be compensated or can it be recompensed? Can you bring back?
no, the right now, man, the decisions of the Supreme Court as they stand, man, the law as they have developed as on date is that there is a provision under the rules to, my lords, penalize illegal extraction. A quantification has to be done on the basis of such quantification, my lords, illegal extraction can be penalized. And then-
illegal extractions, no doubt about it.
Man.
I'm simply asking that suppose if you create an imbalance in the environment,
Man,
can you reverse?
that is not reversible. It's irreversible damage that is. And that is how, my lords, Article 21. They have linked it, Supreme Court judgments have linked, my lords, environmental damage directly to Article 21, right to life. There are those line of judgments also, your lordship.
Also, that's
My
why.
lords, that is the reason why I was driving so hard at that.
Illegal mining activities, nobody will
Man,
support.
that,
And
that is
What must come up very
Man.
strongly
Man.
that you can't do it.
man, can't be.
But because it is the extractions or the mining has to be done in a very regulated manner.
Man,
So the minimum or a minimal damages caused to the environment. But the things are, if it is done in a haphazard manner and there is no control over it,
virtually, my lords.
we appreciate it. But the thing is that you will have to make out a case.
Yeah, but if your lordship, my lords, I'll improve on the pleadings definitely. My lords, para 14, your lordship may kindly bear, let me
Yes.
take your lordship, my lord, to para 14. That it is respectfully submitted that the reduction of the permissible quantity of 33,721 cubic meters to 3,000 cubic meters subsequent to auction on the arbitrary grounds of insufficient mineable reserves is untenable. Therefore, the total quantity for the entire lease period of 5 years is 15,000 cubic meters, which spells a direct loss of 18,721.
That is a different, I am talking about this thing.
month.
Please consider, you are making out a case that in the garb of a 3,000 cubic meter, they will be extracting more than the 3,000 cubic meter.
I have taken the pleading.
This is what says that this encourages the mining. Second point would be
Man,
that the conditions for granting the lease in respect of 33,000 cubic meters are, the barriers are more higher than the conditions which would be imposed or which they impose for 3,000 cubic meters. So that if the higher stringent conditions are given, it really exclude the other persons who are otherwise eligible or may offer for 3,000 cubic meter because the conditions are relaxed.
revenue is one part. The second part,
Revenue is this is the offending the core value of Article 14.
well, that is one. Second part, your lordship may kindly bear with me on the second part. This definitely leads, the last two lines, this definitely leads to a logical conclusion that the lessee is engaged in illegal mining extraction beyond the leased area in excess of the permitted quantity.
How?
That
That is, bring back.
but it's para 16. Para 16. That it is respectfully submitted that approximately 18 acres of land have been unlawfully quarried, while only 12 acres have been leased out for mining operation. The district survey report.
Where is the evidence for that? Only the photographs of the trucks.
No, truckloads and our representation. That is why we have prayed. That is the reason.
Mr. Pani,
Man,
Lord desires to know whether the lines of Article 14 Competition.
Competition.
Possibility of.
Possibility, no, I'll examine the rules from that angle. I'll examine the rule, but.
No, it's not rule. I am again saying,
Man,
please consider
man,
what you are trying to make out the case is that,
man.
let's suppose for 33,000 cubic meter, the suitability or the eligibility must have been judged on the basis of the commercial viability and
Right.
solvency of the.
Solvency and all that, that is there. Right.
So in 33,000, they may put that you must have the capacity to run those. And the turnover, the last 3 years turnover must be around, say 20 crores or 30 crores,
So therefore,
or 40 crores.
Man, that will
Whatever.
come down.
In 3,000,
That
it
will
may
come
come down to 50 lakhs or 60 lakhs.
Suitability.
There may be more than one, there may be 10, 15, 20
Man,
who are otherwise eligible, coming within that criteria, had it been for 3,000 cubic meters.
man,
So you, in one way, exclude them,
man,
making them ineligible,
man,
and then you reduce it.
man,
That's a case of a malafide intentions or a malice which is apparent.
man.
Then you'll have to scrap it and then invite the press tender for 3,000.
3,000.
This is what I really wanted to know. You have not made out the.
Once
You have not made out the case.
I'll improve on the pleadings, man. That should grant me some time, man. I'll improve on it. But my
But
case,
you have to give a evidence
man,
that in a past, for this much of cubic meter, they have put this criteria, and for a larger cubic meter, they have put this criteria. So there is a gulf of difference. If you have to make out a case in that case.
man,
The option conditions.
that. But my case is also that.
And it is not
Your assistant does the correct.
anticipating or apprehending there will be an illegal mining.
No, there is.
Without any-
No, it's not.
Can't be.
There's no
And the
apprehension here.
photographs of a truck cannot be a sacrosanct evidence that they have.
No, you're
How
not.
do you know 200 trucks? Have you there personally and counting every trucks going out?
This
You
is
do not know what are the loads of the truck.
man, this is the.
What are the loads of the truck? If they come within that 3,000 cubic meter,
Man,
you don't know. They have a right to put the truck. They have a right to take out
3,000 meters they have right. But this is what the representation is specifically about. Specifically, the representation talks of that.
Pardon the authorities is also not.
This is specifically what the representation talks about. Your Lordship may kindly talk.
When you have done it for 33,000 cubic meters,
Man.
can you reduce it to 3,000 cubic meters?
Monarch says no, you can't. Monarch International says no, you can't change the rules of the game once it has been.
That is a different process. That you can't. It's a contract
Man,
which can be varied, which can be modified
Man.
by.
I'll just show you Lordship one is one rule. I'll show you Lordship one.
What you have done? How?
I have taken instruction
It always.
for the first time.
That is always.
For the first time, it will not.
When the copy was served on you.
It was on
22/4,
So
24.
for
24.
Mr. Advocate General, when you are there, so let me take an opportunity. I've been noticing this is a very, I would say, sordid state that whenever any repetition, irrespective of the facts that the copy thereof was served 3 months, 4 months back, the council appearing for the state asks that this is the matter first time listed. So adjourn it, let me take instructions. Why not? The moment the copy is served, immediately the concerned department is approached, which is what is expected. And immediately instruction is sought from them and keep it in the file. That would really expedite the disposal of the cases rather than keeping it pending again the listing. Since the matter is not listed, mentionings are done every day. So why not you ensure that everything is done? And this is a case where in April the copy was served.
No, your Lordship is
Now we are
absolutely
in the-
right. I do agree. Let me just also explain a few things. So far, we have streamlined. It was not earlier in a mess.
That's the request we wanted to make.
Let me just
Yes.
apply your lordship. What steps we have taken? Maybe in some cases it is criminal matters, in especially anticipatory bail and bail. No instruction was coming for months. Bail petitions were being adjourned repeatedly, even 4 weeks, 6 weeks, 8 weeks. We have set up a police station here now, headed by an inspector of police, one sub-inspector of police, and the entire strength of a police station, 8 personnel, I think. Suppose bail is filed today, we are also being served with a copy through the elements. So your lordship is absolutely right. The next day, within 3 days, I have given them time, and the additional DG crime branch is directly monitoring. The police people, they are coordinating. Within 3 days, the case diaries are coming, your lordship may verify. And no bail petition, I think 99% of the case diaries are coming. So for the criminal matters or liberty matters are concerned. So that is being taken on priority basis. So from my experience, I have also been experiencing some of the officers, your lordship knows, it doesn't even be placed before the appropriate authority. We are sending letters. So, but still then, my lord, let me go and discuss. I can have a meeting with the secretaries of various departments and with the chief secretary will ensure. The moment a copy is served, we will, no, we have been writing on that, my lord, in most of the cases instruction is coming, we should not wait till the matter is being listed, but the moment they are also receiving the copies, my lord. In the LMS system, no, we will ensure, my lord. This has come to my notice.
In LMS software system, if you can suitably modify that the moment that is uploaded in the LMS, directly the department concerned will know with regard to filing of such a petition and necessary instructions could be imparted in that.
But LMS, they may not be directly able to know because limited access is there. Everybody doesn't have access.
I have come, and my past experience over there was that we had a High Court rules, like here also we have a High Court rules, where we say that no writ petition would be listed before the court unless the copy of the writ petition is served on the respondent authorities. 48 official hours before the date of listing. The reason was that this is the minimum reasonable time given to the authority to give them instructions or respond to whatever the allegations have been made. That was a difference which was given. There is a software like an LMS which is called a Sarthak. Right. There also, the moment the copy is uploaded on that, it not only goes to the office of the Advocate General or the government pleader, there is the post of a government pleader as well. And he is responsible for distribution of all the cases to the respective so it goes to them. It goes also directly to the respective departments. Right. Integrated. These are all integrated software which is already there. We were discussing on the other day that you can definitely modify it. And each department is integrated there. It is a very easy task for half an hour or 1 hour job for a software engineer. He can make those and it will go to them and they will not have an access for all. They have a limited access of those files which concerns them. So they cannot go on that. So that can be modified. The software.
Let me discuss with those OCAC people.
That will help all of you.
Right.
All of you.
But one additional thing, let me also bring to your lordship's notice. This after the petitions are being filed, they serve a hard copy petitioners. I think nowadays they are not serving because the High Court, once it is filed, it is coming to our system. But it is difficult also to take the printout of 300, 400 petitions every day. We have also limited capacity. So nowadays they are not serving the copy. It's a computer generated sheet which we are, so hard copy we are not having in most of the cases. So the moment it is listed, they are being notified that such and such matter is coming, so take a printout. So your lordship, I may request your lordship also to direct the registry to serve a copy. That is the rule. Your lordship is absolutely correct. A hard copy of the writ petition is to be served. Suppose there are 4 or 5 respondents, but one copy that was being served on the State Council or the Advocate General's office with a copy to be filed along with for the removal of defect. So nowadays that is being dispensed with. That is another difficulty we are. We are not having the hard copy. High Court rule provides that a copy is to be served. Otherwise, that will be pointed out as a defect. So the parties are also not serving. I think they are not serving the hard copy nowadays. That is the difficulty. We are having enormous difficulty.
No, we have in objection notes, one of the column, receipt showing service of copy.
They are taking the printout of that. Once they are filing in the High Court filing, they are taking a copy, that copy served. Though in fact, reality, the copy has not been served. Digitally it is served. But Milan, physically it is not served. So to take the printout of 300, 400 petitions a day, bill petition, everything, our system also equipments will not support. Lakhs of pages. So that is also another difficulty. Your Lordship may directly register, I would have requested, because that difficulty we are also facing every day. Briefs are not being ready even when it is being supposed.
Who will take a responsibility? Suppose if they have to give you a hard copy, then who will take a responsibility?
That was the practice, Milan. Recently, only 2 months, 3 months. There is a counter. We receive it. Only 4 months back.
No, he
Council will file. That is the rule, Milan. I could rule unless a copy. Now, once they say that we are sending the copy digitally to your office, so therefore the party will not file.
I will verify this problem, which
I have not, but my impression is my office probably serves all copies. The typing stage itself will make extra copies and possibly my office does it.
has to take a call.
Manoj?
Bar Association has to take it.
My instruction is probably my office does it. It files.
No. In no case, they are not filing copies now.
That
Petitioners. That is the difficulty also. Another, this was pointed out once I had discussed during the minor previous suddenly they stopped it.
Yes, sir.
The difficulty is that we are heading for a paperless court.
That's true.
But Milad, you will not do that.
After paperless court.
Thing is that everything is in a soft copy is.
That is true, Milad, but
Councils are also really these systems have been put so that they can argue and on the soft.
but I welcome, I appreciate that step. It is laudable. But the question is the difficulty. Everybody is holding a hand, including my friend. Hard copy books are, Milad, I have no substitute of
I'm
paper.
not very tech savvy.
But
Not very tech savvy.
I am also not.
My experience
I'm very
is different.
comfortable with paper.
My experience is different.
Physical copies.
There, the insistence is that you should give me a soft copy.
Your Lordship, kindly, this is the automatic generated copy. File the petition in the High Court registry. This copy they are filing. So the stamp report should have pointed out that this is a defect unless a copy is physically served. That is also another difficulty for which we are not getting the copies in time.
No, I appreciate it that the moment they upload, that means they send it for service, and unless you visualize it, it cannot complete the service.
Right.
Similarly, you just send the copy to post,
Right.
and the moment you lost the articles with the post office, that does not mean service is affected.
Service is different.
It is you have sent it for service, and then once it is received, then the service is affected. I appreciate it. That's why if there is a time gap which is given, like there, that 48 hours or 72 hours, whatever. And this time lag, because you can go through and open the portal every time.
Right.
Your office is well equipped. So they can identify that whatever has been given. So they can do it because nowadays we have to embrace the technology and how best
we
we can use it.
There was technology, there was nothing. I recruited around 37 people here after I joined. There was nobody.
I'm telling you that technology we have to-
Yes, we talk up. So therefore, we are developing, but overnight it can't be done. This system, when
Please
it goes,
ensure
it
at
runs for me.
least for the time being, please ensure if it can be modified, the software. If it is not, please department must give an instruction immediately once they receive the intimation from the concerned advocate who is representing
Well,
them.
that I will ensure. You
So-
know what, it's
so
invariably
that's
coming.
that at least the prompt,
Many cases,
reaction.
many cases, it is coming from various levels, not that it is coming from Bhubaneswar. It may come from a district office, it may come from a block office, from a tehsil. So
Everybody is given an internet access. Nowadays, even a remote village has an internet access. They can do it. They can use the WhatsApp. They can use many things by giving an instruction. There cannot be any problem in this regard. Only thing is the jilt. You must have the jilt to do the work. If the authorities, they feel that there's your responsibility to do it, they will definitely find out the solutions. There is no difficulty.
no,
You can contact the advocate immediately and give the instructions. So let the, please ensure your office, your exercise your office and sensitize them.
I'll definitely.
If why, please do that. That's a request from the patient.
No, we'll do that. We'll do. Let me go and have a meeting on this.
Yes.
Number two, this copy service. Your Lordship may kindly reintroduce the same system. Unless we are, no, we are in this. It is difficult, Mila. It is very difficult because they have been complaining also before. They are not getting the copy in time. Lawyers, even the government counsel, they are getting the copy before 9.
This PDF form, the soft copy is immediately given
Soft
to
copy
the-
is fine, Milord, but
they all have their iPads with them. They can, and this system is also here.
so the rule has not been amended. The High Court, without amending the High Court rule, by an executive order, Milord, circular, I think that was done. And no copy need be served. So no lawyer is serving. At least one copy is the office is entitled to maintain a record. Every day, we can take the printout of 400, 500 briefs. Some briefs are also very voluminous. The computer, it's fine. That they say that it is integrated, it is going to their LMS. Suppose for some reason, Milord, they don't get a copy on that night uploaded. It is also getting difficulty. The next day, the cases are being listed. They are filing it today, the next day on urgent mentioning that is also coming. So the copy is not available even with the office, with the section.
Definitely, we'll see to it that at least some time gap of 48 or 72 hours.
Right.
Is given that it will not be listed nor it will be published.
Your Lordship can do that. At least,
Do it so that.
like
at least you
Supreme
get
Court,
a-
it is
get
not
a-
being
at least,
listed for 7 days.
time. And that is required because of authorities have to collate the
Right.
papers and all that. We appreciate that.
At least
That
a
is
week's
what-
time.
That was a rule which is framed there.
That's correct.
Rule says that before
Yes.
that it cannot be listed.
Supreme Court the same also, Milord. Today it is fine, it will show a computer generated date after a week. If somebody makes an urgent mention, the other party
Correct.
is to be notified. So we don't have any notice that the matter is coming tomorrow. At 11 o'clock, my officers are getting the brief in night. So
No. Yes, yes, sir. Please improve upon the previous transition. On the prayer of the learned senior advocate of the for the.
Item 5, Manoj, on the last occasion, your lordship said directed the state council to take necessary instructions and Manoj.
this is the instruction.
First, proper departments have not been added as party, because there is an allegation of operation of the stone quarry.
Order dated 76.
Yes, I have seen that.
Paragraph 2 and 3.
Yes.
Paragraph 2.
So there was no siren.
No, sir.
Huh.
But only,
But excavation is going.
but the opposite party, the private respondent, has been licensed to operate the stone quarry in Sanavo Wari sand quarry. But the allegation in the writ petition was that he's operating the stone quarry in another area. So that was the allegation.
It is
In
sand.
sand quarry in Porisankhai. So that was the allegation. But your lordship may kindly see the instructions which I have received. These instructions had the mining officer would have been included as a party, I could have received. But in any case, the Tahsildar has given the instruction. Your lordship may kindly see. Based on the paras.
You need the filing the affidavit, bring it on records, what can be done?
Yes.
When we file the affidavit, we'll.
Yes,
Pursuant to the order date 76 will be produced by us. Or the written instruction is submitted first. Indicating that there is no illegal and unauthorized operation.
Collector is still the controlling authority. Collector is still the controlling authority, and he has to let them file.
Item number 6.
At this item number 6, let me, we have done the last occasion was regarding the appointment of in charge vice chancellor of Utkal University. But actually, it has a checkered history. In since 2020, there was continuous litigations. In 2020, the government got out some amendments in the existing University Act of 1989, and the mode of appointment, recruitment of vice chancellor was completely amended, which was alleged to have violated the UGC Act. Your lordship knows it's a concurrent subject to entry 6366. So the Honorable High Court, this court upheld the validity of that amendment of 2020, which took away the representation of UGC, etc., etc. Finally, the UGC, the Union Government, filed a SLP against the judgment of the High Court. It is still pending on a different issue. It came up only on 7/5/2025. I was also arguing that matter. No, just a minute. I am conscious. Let me just explain why this.
You were there.
No, I have read. Yes. Previously, you lordship may kindly look at this order. 6(3) subsection 3 of section 6 deals with the appointment of the vice chancellor, the constitution of the committee. So for the last 1.5 years, because of the interim stay granted by the Honorable Supreme Court, the process would not be initiated for the recruitment of regular vice chancellor. So after the expiry of the period of the incumbent who came to be appointed in 2020, so we had given a temporary extension of 6 months. That is not permissible beyond 6 months. So somebody has to be kept in charge. All the universities, also state universities, are having the same problem. Like the Ravensa University is also an extension, we see. North Odisha, Baleshwar, only two VCs pillar. Their tenure is not yet complete. I think Sambalpur and Barampur.
They are also in additional charge.
Just they are also in additional. So therefore, the previous section your worship may kindly have. There is a wrong conception. Actually, the section there is a misreading. 6 below the previous old provision 89. That has again undergone an amendment. 610 million. Your worship may get it from the book. So there it is any person. In case the office of the the same thing now, it was in 2020 amendment vice chancellor of a neighboring university. In 25, we amended it. Any university, public university, but earlier it was any person. Even the RDC Revenue Divisional Commissioner or the Higher Education Secretary, he was also kept in charge for the interregnum or until the selection. But now that there was no, somebody has to say statutory post is filled up. Let me read 10. In case the office of the Vice Chancellor falls vacant due to any other reason, the vacancies shall be filled in the manner specified in subsection 1, that in regular mode, and the person appointed to fill such vacancy shall hold office and shall be eligible for reappointment in accordance with the provisions contained in subsection 7. This proviso has undergone amendment twice, provided that where it is not reasonably practicable to fill up the vacancy in the manner aforesaid immediately after it occurs, the Chancellor may appoint a person, that this is a person, to act as the Vice Chancellor for such period not exceeding 6 months, as he may fix, and the person so appointed shall exercise. This is in charge. So there is a actually misreading. I was very last night it came to my notice. At around 11 a.m. I called the Higher Education Secretary. How could you do it? It's a mistake, I admit. So therefore, what is to be done? I have told them to make necessary. In the meantime, the process, my lord, after this order of the Honorable Apex Court, we took that liberty from the Supreme Court to proceed with the
Recruitment. It says that you can't postpone the recruitment.
right. That was stayed, my
Question
lord.
is-
So therefore, 6-3 was the crux. That is the appointment
Now, the
committee,
question
etc.
here is that whether the professor in a particular of a subject can act as a vice chancellor, which is in total departure from the rule, which says that it has to be by a neighboring vice chancellor who will be given.
No, neighboring is not there.
That is what.
No, neighboring has again been amended.
Where is that amendment? The
No,
last amendment I just
I'm
wanted
giving.
to know.
I'm giving.
Please give me the last amendment.
I'm giving the 24 amendment.
The last amendment I have also given you, no?
Given where is that?
Not neighboring, my lord. The language is neighboring has been substituted. Any university, any public university.
The red is, the green is a 20 and 40 red.
No, he's referring to,
I'm referring to your amendment.
this
Yes, please.
amendment is.
Let your lordship
This is
take
here.
kindly.
It is here. I think you are referring this amendment which is notified on 17th April.
Yes, ma'am.
17th April.
April.
Yes.
Say, please, which one?
10 million. G million at page 9, your lordship would find up together.
Internal page 9.
Your lordship is holding
What
this
is I?
gazette.
No, I'm holding
Yeah.
that.
9 million. G. Small g.
Yes.
In the proviso, internal page 9.
Yes,
Small g.
yes.
In proviso to subsection 10. For the words, Chancellor may appoint any of the Vice Chancellor of a neighboring. The words, the Chancellor in consultation with the government may appoint any of the Vice Chancellor of any, then it would be read as public. Other words remain. Any shall be substituted.
Now then what emerged? If
Then-
this word is substituted,
Sub-
where is the, let us go to the proviso of subsection 10 of.
Yes. The principal act, you will see how to. No, 20 amendment now we have to see.
20 amendment,
20
page 8, my lord. 20 amendment, page 8.
20 amendment was 20 amendment.
Original, yes, your original is here, and this is subsection 10 of
Orissa
Section
Industry Act
6.
1980.
Section 6.
of section
6 million.
Section 6.
The original proviso I read, this proviso was substituted.
Just 1 minute. Any of the vice chancellors of a rule, this word is used. Now, it is amended at page 9. The word in chancellor in consultation with the state will appoint any of the vice chancellors of
Any
public
public
university.
university. That has been substituted.
So now still the vice chancellor.
Yes, sir.
So
Your
not
Lordship is
neighboring.
No, no, Your
should
Lordship
be
is
of
correct.
public university.
No, Your Lordship is absolutely correct. I don't
No difficulties.
No,
Just make a very material changes.
That's it.
No,
it was never-
How a professor can be appointed as a.
No, Your Lordship, that is why, let me discuss, because Chancellor has to be consulted. I have already discussed with the Honorable Chancellor, Governor. Let me work out, Your Lordship may grant 2 weeks time. No, that is the crux, I have understood. So we we are going to make some arrangement today itself. So I could not say that. So let it come after 2 weeks. In the meantime, we have to work out. But my lord, the application process is over. I have understood yesterday at 11:30 I had to intervene. Mr. Das told me at 11. Your Lordship may see the call. I called up everyone concerned, including the governor. So we may correct it in course of the day also. Let me just see. So, but the number 2 issue is, my lord, Your Lordship, the process is already complete. Application. After the 7/5/25 order of the Honorable Supreme Court, because applications could not be invited. So regular recruitment process is already on. 378 professors from various universities of the country, they have applied. For one post of vice chancellor in UDI, it's a very prestigious. I am also a student of that. Mr. Das was my classmate, in fact, the PIS. It's not mentionable technically. He is not a claimant, I think, is a service matter. But anyway, it's a public cause. But
My lord,
everyone.
as far as the recruitment of regular vice chancellor
He's
is concerned,
like-
I have no problem. But
Oh,
the
so what he says, he has admitted that
Yes,
this is a wrong which is committed.
Yes.
Only thing.
No, let
that
us put up
he
the
is-
file in person.
he is going to rectify the wrong, redress the wrong, and simultaneously he is saying that already the process is also on.
Yes,
and,
maybe
it's
over
going to be
within a
complete.
fortnight also.
So if they take a decision today or tomorrow and then
May
appoint
take
any other
time.
vice
Vice
chancellor
Chancellor is there, officers are there also.
instead of this gentleman,
Yes.
there is a difficulty.
no difficulty.
Utter ends, that is what he wanted.
Yes, ma'am.
It
They are
can't
all
be, there
interim
can't be a
arrangements.
vacuum.
They're
That
all
is-
interim arrangements with the
Interim
university.
arrangements. He is the senior most professor of the university.
Otherwise,
No,
also,
it is correct. I
Correct.
too agree.
You'll have
I don't
you'll have
say
to
it
do
is correct.
something. You'll have to do something immediately and
No,
whatever.
I just.
We
from this regard. Secondly, Lordship has called for instruction.
I think the superintendent of police vigilance, your lordship. The vigilance department has to take notice, your lordship. Notice has to go to them. And the prayer is also specific to them, your lordship.
What is?
Madam.
The opposite party number?
And then,
Seven. 3 weeks. Yes.
Item number 8.
Give your lordship. The given also directed. Yes, release to comply the order. Charged on reply.
What do you instruct?
26 to 7/20. Something annexure 7.
37, please, 37. Whether they included that this one?
no, your lordship, since it was not submitted online, your lordship,
Okay.
so they have not considered.
Along with the application, it was not.
No,
Give a very short affidavit. The state is directed by counter affidavit within a week from date.
I have challenged the order passed by the Excise Commissioner on the Annexure 13. And he has not considered the written order submission in the Annexure 12.
Yes.
The Lordship yesterday.
records, your lordship, that has been accepted. The department is saying that it was that.
But there's no reflection in the order.
No, but your lordship, it was not uploaded in the OSAC website and it has not sent to the required section. But it was.
That is
given
the
to
that
the-
is on your part. That's the that is on your part. So you'll have to consider this.
You know, omitted to the excise.
Yes.
So Lordship's earlier order is at page
No,
61,
I-
Annexure 11. That was the direction Lordships have directed earlier.
What?
I have approached.
No, we are talking about your only contingent was that you have filed written notes of submission.
Yes.
Raising the points.
Yes.
Those have not been taken into
Yes.
consideration. And therefore the order is
Yes.
so one-sided one. But the order of the Commission of Excise passed
Item 10 also, here I have filed an application for shifting and I have deposited 3 lakhs rupees. But here also the commissioner heard the matter on 29/5, but he is not passing orders. This excise
What are
commissioner.
we doing? 1 week, you take instructions. If he has passed an order, communicate to him, let him challenge.
Today I have obtained
If he has
instruction.
not, then he'll have to pass the order. 1 week.
Item 11.
May I please motion? Your Lordship, I'm challenging the termination order, Your Lordship, termination of the contract, which has been passed in violation of the stipulations of or terms and conditions of the contract. So also in violation of the labor laws, Your Lordship. Lordship, on the last occasion, Your Lordship was of the view that a direction was sought for from the counsel of the opposite parties, Your Lordship. So as to the reason of such termination, since no such reason has been, no such adverse report has been communicated, Your Lordship.
Who is authority who terminated?
Was it
Your
Niger?
Lordship, Your Lordship,
Niger.
You are
Niger,
representing?
yes.
Unilateral termination.
No, my lord. There was a tender. The petitioner has participated. He has suppressed all material fact before this honorable court. My lord. There was a tender floated by James Portal. The petitioner along with 68 others have participated. 29 were qualified in the technical bid and thereafter took place and opposite with the Laxon Associate. He was the successful bidder, my lord, and thereafter, my lord, this order was issued. Thereafter, the order was issued because the extension was given at the request of the petitioner for 6 months. The language is
so that there is no disruption in the
no, there
service.
is no disruption.
So that ended after you finalize the press.
Yes.
tender. The tenure expires.
Tender petitioner has participated in the tendering process. I'll file a detailed counter, my lord.
This is not a unilateral. Your termination was done because the extension was a conditional one.
Yes.
Yes, Your Lordship. I'm not challenging the termination per se, Your Lordship. What I'm challenging, Your Lordship, is that as per the terms and conditions, it was bilateral.
Did you participate in a fresh tender process? As he said, yes.
Your Lordship, I don't have
You
instruction.
don't have our instructions. And if you have suppressed this,
No.
then why not? Please bring that on the affidavit.
Yes.
2 weeks time for filing the affidavit. Particular period of months.
Item number 12.
I'm appearing for opposite party 2, 3, and 4.
Please.
Yes.
Let him give you a memo of appearance.
Already I have given that. This is my name appears, my lord.
Yes.
Item 12.
Let's call the things.
Item 12.
Item 12, Lordships. On behalf of the Paradeep Trust, caveat. That's number as 908 of.
It's already short.
Yesterday, but 9 just because I didn't know that matter is coming today. Any, let's one day.
Shakespeare says that what is there in the being.
Yesterday they gave me, and there, let's,
Speaking,
no.
Once before the law there, Indore has been quoted for the maintenance of that vessel.
planning operations and maintenance of a pilot launch.
And I have participated and found suitable. I have participated and accordingly I have deposited my bank guarantee under annexure 2 below. Work order has been issued in my favor. That is under annexure 4.
Then
Then there is a clause for termination of the contract and there is a provision for appeal to the authority for conciliation. And thereafter a joint inspection was made under annexure 5. In joint inspection, your lordship may turn to page 69. There are several parts has been damaged of that vessels. Your lordship may turn to page 69 for a moment.
yes.
That is joint verification made by the Paradeep Port Marine Engineer,
Yes.
Chief Officer Patila, so also the present petitioner. Your lordship, from serial number 21 to 34 of the page number 69, the deck side status is damaged. So far engine side is concerned, your lordship, serial number 1, 2, then 4, 5, and 7 last part, that is 12 and 13 are all are damaged conditions.
Even though there is an work order, I have accepted and the vessels. Vessels, thereafter, I sought for the permission to maintain the same. When I sought for the permission, my lord, I made an invoice that has been rejected. However, I maintained the vessels out of my own income. And your lordship, there is another verification. Your lordship will turn to page, sorry. After maintenance of that damaged vessels, at page 76 annexure 8, in the year 2023, my lord, just 1 month after, there are several defects has been found in the port. So also in the deck side as well as electric side, electrical verifications, engine side, so also other basements. And as per their direction, I have corrected it, made the certificate and made the vessels as in conditions. Thereafter again, time and time, it was damaged the parts. They have issued a show cause to me. Your lordship turn to annexure. That is the crux, my lord, annexure 14 at case 96. A show cause notice has been issued on the stating that the vehicle
Is
96, my lord.
From January 2025.
My lord, 8th May 2025. That is the show cause notice.
Oh, this is because you could not maintain.
Yes, they have stated that
Becomes non-functional.
non-functional for 25. And I have explained the difficulties, what are the rectification has been made under annexure, my lord, 15 on May 15, 2025. And the vessels in their custody.
Where you have given?
At
Explanation
annexure 15, my lord, page 99 through mail on 15th May 2025, my lord.
Oh,
My lord, thereafter, what happened, my lord, whether they have disposed of the same, it is up to them. Immediately issued a notice for termination. Kindly see the crux, that is annexure 16, page 101. Notice for termination of contract for manning operation, maintenance of pilot towards Surendra Sir for a period of 3 years. My lord, by that time, that's 2 years and 5 months has already been over. Your lords may kindly see they have terminated notice. Through notice on the clause 12.
Clause 12 of the work order.
Yes. My lord, kindly see the annexure 4 at page 68. Sorry, 65.
Work order starts at 60.
Yes. Clause 64. Is 64 clause 20. A P provision was there.
I'm talking about clause 12 is the.
Sorry, sir. Sorry.
That is page 63. Yes.
63. May I permit you to read that? The contract shall be terminated within the contract period for the reason of major breach of
The
agreement.
power to terminate has been given by giving a verbal notice.
Yes.
Then
And along with the forfeiture of performance of security deposit shall be debarred from participating in any tender of the Paradip Port Authority for a period of 2 years. My lord, there next, my lord, at page 64, there is an appeal provision. Clause 20.
yes.
My lord. After so cause, my lord, and after receiving my explanation, though they have not stated anything result of that explanation, they have issued the notice of termination under annexure 60 at page 101. And in request for conciliation, my lord, I have submitted my request for reference with dispute to the conciliation board, the annexure 17 at page 102. That is with them.
It was when,
My lord, on 11/6/2025,
after the termination.
after the notice for termination has been issued. And I preferred an appeal also. Then I preferred an appeal.
Where
The regular appeal, that is annexure 18 at page 104.
Before whom?
Before the appellate authority, that is the board of Paradip Port Authority, represented through the chairman.
Then
Then, my lord, what happened? Now they have terminated without issuing any notice or without any letter and blocked the vessels.
what has happened to the appeal?
Appeal is pending with them. Explanation is also pending with them.
You can't keep,
What has happened after the 1 month has passed, the termination letter was issued on 4th July.
June.
4th July. That was the notice for termination. You have not said subsequent. They have not communicated. No, this has been communicated. This is the final order that 1 month was given. He submitted a explanation. Thereafter, this order was passed. Then appeal has to be subsequent to this. No, appeal was filed on 25/6/2024. Again,
He has filed appeal against that notice.
against that notice.
So there are mechanisms. If there is any dispute, that the dispute can be resolved through conciliation.
Yes.
He has already approached the authority.
We have no objection. Rather,
You have not permitted him to exhaust that remedy.
No,
There is an appeal, means they can go raise a dispute, the appellate court may resolve the dispute. You have not decided it.
but that is only for the amicable settlement. What has happened in this case?
But that shows that you are heading with a.
No, let's say, your lordship may see the letter at page 96.
Did you give them?
Now, what has happened? What has
Give
happened?
them an opportunity of hearing when show cause. What has happened to a proceeding initiated on the show
No,
cause?
he wrote a letter. That's what has happened. But I understand what was the emergency situation or ships that we have given page 96, your lordship.
It should cause notice.
It is a show cause notice. That was a fire to this particular millets all throughout. He said, even gave it in writing, your lordship, that is not annexed here. That I do not have funds to manage the vessel. Millets, now this letter is not. Now, millets, that's a pilot boat which attracts all the vessels inside the port area. Millets, number of letters were given. Finally, he says in that letter that, but they are, this is to inform you that we have not contracted such and such, but spares, but they are requested to pay the advance payment along with the pre-request. We are running short of fund because of non-receipt of payment for the month of February. Your lordship, this is a March letter. Up to January, everything has been paid from the. He says that I do not have fund to manage the boat, which is the key function of this millets. So, millets, after this millets,
you have not paid for the month of February.
No, month of up to January. This is a letter in the month of March. Up to January, everything has been paid.
But he says that he is not saying that up to January it was not paid. What he says is that I have not received a payment for the month of February. So 1 month period you have not given.
But from January 2025, your lordship may see 6th January 2025, the development charter, he was all throughout not managing the boat. And millards, there was a fire to the boat, and that's it.
Bring it on record.
Millards.
Item 13.
The order may kindly supply to me. Yes, my lord. Let him supply the documents. Yes.
Both, those defects, defective both was the.
No. That's 2023. He is showing all the letters of 2023. Now, up to 25, it was all right, all things was fine. He didn't maintain the boat. There are number of letters.
Give all the.
Well,
Item number 13.
Lords, here the petitioner has assailed annexure 1. That is a sale notice, my lords, in respect of his OS shop, whose license has not been revoked to his knowledge. Lords, what happened is this. I am the exclusive privilege of that shop. And a demand notice was issued to me in the year 2022, which I have challenged before this honorable court. I have annexed that demand notice, my lords, as annexure 2 to the writ petition, my lords, at page 18. And I was asked to deposit 60,82,680. In the writ petition filed before this court, your lordship directed as an interim measure, subject to my depositing 50% of the demand. No coercive steps to be. Page 19, my lords.
Page
19. Annexure 3, I have annexed that order.
So you deposited. 50%.
Yes. I have deposited and accordingly, my lords, no coercive action was taken. Again, my lords, for the next year, they issued another demand notice. That is annexure 4 at page 21. And there, I stated, I made a representation that 3 of those shops were non-functional. Money is there with the excise department and it could be adjusted against that demand and the balance be refunded. Now, to that effect, my lords, the collector wrote to the excise commissioner via annexure 5 as regards the prayer, page 22. The excise commissioner told him to take appropriate decision at annexure 5/1, page 23. No decision was taken, but a demand notice was again raised, page 24, my lord's message. Annexure 6 at page 24. They say that though you are directed to deposit area consideration money of your OS mail and branch shops relating to 22-23, you have not deposited the same, nor taken steps for renewal of the shop for 23-24 as yet. Hence, you are directed to submit your show cause as to why your shop shall not be settled afresh at your own loss and risk.
23 of the.
My lords. So I made a representation, my lords, to that effect again and came up before your lordships. The order of your lordships is at page 26, my lords may see, annexure 7. Annexure 7 at page 26, your lordship disposed of.
Then what happened?
My lords, after that, my lords, they have not communicated anything, though the order was communicated to them. They have not taken any steps, my lords. And suddenly, my lords, annexure 1 was issued. When annexure 1 was issued, I came up in a miscase, my lords, in the first writ petition, my lords. That matter was listed before the division bench last week. Justice Raman was there with Justice Sahu, my lords, because this bench was not functioning. Your lordship said that their lordship said that it will amount to extending the scope of the writ petition. So I have filed the present writ petition.
It should be not been served with a copy.
Okay.
Copy of this writ petition.
Well, that has been solved.
PDF.
Yes.
This
You have a copy? Why don't you raise this issue immediately when you open the bill?
Lordship thought it
You
was.
could have said immediately. Unnecessarily we heard so much.
Instructions.
Give a copy today.
I also have another copy right now, my lords. And I have also filed another IA today, my lords. That is IA 11337 of 2020.
You serve the copy. Come on, Monday, next Monday, it's going to happen.
So because they have already millers, because of the personal.
On the applications they will receive, let us see.
I'll serve copies. Right now, it's.
Years. For the state and submit here, the copy of the resolution has not been served for me, so no. And therefore should have the ability to address the court on the issue.
Item 19.
With a very heavy heart, I am mentioning, my lord, this matter, my lord. This is a content matter, my lord.
Why you did not mention in the morning, sir?
My lord, because now.
Morning is a day, is a time for maintenance, please. Do not break that agreement. You come tomorrow in the morning, that's it.
My lord, my lord.
So for the item number 39 million, kind. I can reach today.
My lord, only the petitioner's village, only 4 kilometers from my lord's post, my lord. They are residing with water logging since last 3 weeks, my lord.
Come.
This
item number 39 is here.
My lord.
We will take up, don't worry.
Kindly taken up today, my lord. They kindly see
While you underestimate the pace of the court.
My lord.
Let us see.
Item 19.
19.
This item is covered by your lordship's order. This is the issue regarding single consolidated show cause notice for multiple financial years.
That's it. Here slightly, my lord, I have to submit that the order has been passed in and separately. My lord. Your lordship starts from phase 1.
What is the genesis of that order?
My lord, all these.
Notice.
The so cause notice. True, my lord. But the initiation of the proceeding is doubted by the petition only on the ground of limitation, whether it is confined to the limitation period or not. If your lordship sees.
What is the initiation of the proceeding?
Show cause notice. Show cause notice.
Is it a defective or not a defective?
It's not defective. Here, not the.
Have you not included all the several financial years into one notice?
Yes, true, my lord. I have included. But thereafter, my lord.
The notice appears to be bad. But when you have passed the separate order for each assessment year,
yes.
Is it cure?
Yes, my lord, because yes, it is clear. Because your lordship see, all these orders have to upload in as per the section 146 in the portal. Your lordship see for a moment, your lordship see because order has been passed and the DRC 07 lordship see each and every year DS7 demand has been quoted.
Order may be one, but it has to be annexed in the DRC
For your
07.
lordships, the order is one. Lordships may have me at page 255 for a moment, your lordship. Para 13.0, your lordships. Here it is clearly written that the amount is clearly written, and the entire period is from July 2017 to March 2022, your lordships. Only when demand notice in DRC 07 was given, it was dissected and multiple DRC 07s were issued. If your lordship sees those, all of this DRC 07 also, the order is one, your lordships.
Yes.
So therefore, one order encompassing multiple financial years. Even the show cause notice was one show cause notice encompassing multiple financial years, 5 financial years.
Order,
Yes, your lordships.
bifurcation is made.
No, your lordships. No. But it may have me at page 250.
And all the bifurcation 07. Summary of the order attached in the DRC 07. So DRC 07 has rules. The rules provides that in each form, the order has to be attached. And if your lordship see, all the form the demand has been quoted. So, so far the question of limitation is confined, Lord. It can be ascertained by this 07, because only issue was there, Lord, when lordship has passed the order. In multiplying the order, whether limitation will apply or not. Suppose Lord, it confined to 5 years, the start of filing a return and thereafter Lord, the limitation will start. But here is the Lord 74. And all the limitation, all these things are covered by this, even if confined to 1 month.
Here under challenge,
If your return period
Yes.
is self-assessment. Self-assessment.
Yes.
Each return is a self-assessment. So, self-assessment, each return is a component of assessment.
Right.
It is subject to scrutiny.
Yes, yes.
Any defect or subsequently found which is not incorporated in return. There are proceedings. So each return which did not incorporate, which escapes self-assessment or otherwise, then each period, tax period, is a separate component of assessment.
True.
So you are to take up each return as a separate orders have to be passed.
Period.
Period. So how can you club up entire?
No, it is notice has been issued for this years now. But when the order has been passed, order one order, but the lordship see DRC 07, each and every year quantification is there. Therefore, my humble submission is not. Lord, the whole issue was the arguing the earlier issues only confined to limitation. Suppose 5 years has been quoted in the notice, then limitation cannot be quantified because limitation has 3 years, and if not, then the 168 on single other issue was there. But here is 74. Investigation has been conducted. An investigation one issued is 70 summon. In summon, they have stated that all this year has been.
Sir, when he submits the return, then each return constitute a independent cause of action.
Each period, not
a
statement. Each period.
Statement by virtue of any practicing the fraud or something of this kind. So it can't be a common thread. There must be a fraud is of a varied form.
Correct.
So one may be one form of a fraud may appear in one particular period. That may not be there. It is a secret.
Yes.
Will you not spell out separately indicating, adjudicating that this is what is done?
That is spelled out. That is spelled out. DRC 07 is summary of order.
Then the total
DRC 07 is summary of order.
you have done. The total amount which you have then you have segregated those amounts.
Because period
Because of the period.
Yes.
Segregated this. The difficulty is that it permissible.
No, it is so far I am concerned it is permission.
But the judges have to be concerned.
Yes, correct.
You are.
But no, so far my understanding law, my understanding limited understanding, Lord. This DRC 07, your lordship see, the rules is confined that each and every.
You can't have limited. Sir, you have so vast experience.
Every DRC 07 or RAMAN to attach. We have to follow the rules. Rule says in every DRC 07 order has to attach. In the DRC 07,
you have segregated the penalty of this is a composite penalty. for each period?
No, my lord, yes, that is in 007 your CC.
This 25,000
Yes.
you have said.
That is not, that is for contravention. That is for the contravention.
For each period, God has.
Yes,
to
my lord,
report.
that is there, that is there.
That's how you have segregated the composite penalty for several years.
Divided by two.
This one.
Median mode of statistics.
That's what the because notice period, notice he has not challenged. He has challenged the order and the notice. So, yes, I understand. Both he has challenged.
I challenge show cause.
Yes, both you have challenged.
Just write down that you should revise the department. It is not, it is not like bad.
No, it's not like.
It is not like bad. That BD Patnaik case will
Yes.
happen. 7 years backward calculation.
No,
Delete the.
Here there is no scope at all.
Proceed further. It is not null and jewelers also. Composite assessments can be done.
Yes. But that is what my son was saying. That is what my son said. But that is the instruction I have received.
So we have kept pending.
Yes, that doesn't.
Coming up
Some cases.
your lordships, other matters are
Some cases are pending.
That matters are pending. with
Yes, sir.
But there are only difficulties. There is no such separate DRC 07. That is
Other
only
matters,
difference.
lordships in other matters also there are different DRC 07. The matters that I have given there are different
Yeah,
DRC.
arising out of Madras, under Madras High Court, they are only confined. There is no such DRC.
Madras and
07.
Karnataka,
Yes,
where
correct,
Reliance and Titan
But
Industry.
yes, 07 is defective as you pointed out. Not pointed out, I have pointed out, but.
Yes.
Yes.
Obliged.
Correction, make
Yes.
corrections.
Yes, sir, lordships are already.
Item 22.
Item 22, Your Lordship, I'm on VC. This is regarding registration, cancellation of my registration certificate. My associate is there, she is passing on the covered order.
Yeah. You are not good.
Item 23.
23 also for pilot in absence of GST tribunal, first appeal order is done, sir.
10%.
20%.
10%.
10%. I've given 10%.
10% before the other 10%.
Yes, yes.
Give.
No.
Before the other 20% is what I'm saying.
10%.
Yes.
First is 10 or 28?
First is 10.
And
Then thereafter I have to pay another 10.
traveler, how much?
10% of the balance amount. Yes.
So not 20 plus 10.
No, that has been.
8 plus 10.
That has been amended.
Yes.
I've given the similar order.
Yes, give.
When is it coming up?
Balance 10 of the remaining tax amount. Remaining tax amount. So that 10% will be deducted then.
Have you verified this order?
Yes, sir.
Yes. Let's call the next.
Item 24.
Item 24, Your Lordship, is similar to item 22. This is also regarding registration cancellation.
Yes.
I'm passing on the.
Yes.
You have not given it. Sorry? Give it to the other side.
Yes, आपको देखेंगे.
Only one copy.
Yes.
Item number 25.
Obliged, Lordship.
May I please, Lordship? So read appeal against the order dated 10th of January 25 on Annexure 3, page 129. The fact of the case is that, Your Lordship, the petitioner has applied for the order at page 129, Your Lordship, Annexure 3. Start with page 131. The portion is paraphrased. I'm sorry. Is there a set formula of determining the extent of disability? There is any kind of standard format having taken here? That up to this, it will be this much of percentage, up to this, if it is like that, then this much of percentage, anything where you have set up?
The Person with Disabilities Act. Yes.
But there is no formula that how to ascertain the percentage of disability. I'm talking about.
It is only by the experts. My lord. But
I
what
had
is
a
the
different
what is the
experience
standard? My
When
lord?
I'm putting a question to
My lord,
you,
I understand.
there I had a different understanding. There is a complete chart, is a format which is given. If it is one small tip, then it is only 0% or 1%. If it is amputation or there is an amputation of 2 fingers of the left hand, then it will be considered to be the 1% or the 2%. This is what is a standard parameter which is given. Because I find the disparity, because the first medical board says there is no, it does not exceed 10% or 11%. The appellate examination whereby appellate medical board says 21%. He claims 45%. Now this disparity is coming up.
Yes.
Now how to rule out this kind of a disparity in future?
And moreover, if I will permit it,
Sir, it is an expert who has absolute authority. Now the difficulty is that the medical board did not found that you are suffering so much. Your certificate has been doubted. If the rule provides that you have to undergo with the medical examination by the board, and if the board has done that, then
but my post I'm laying down is that the first medical board, that if you find that page number.
And what is the parameter? How much of percentage?
What is permanent?
Not less than 40% a degree of disability to be considered for reservation as per the Disabilities Act.
Correct. So it must exceed 40.
It must exceed 40.
Or 40.
Here petitioner
At page 50. I'm
So
sorry.
understand, you obtain the certificate from, I do not know from where, must be from hospital. It says 45%, it is more than 40.
I have received.
But both the other, it is the board and the appellate board did not find that it is 40.
40.
Now whom to believe?
The competent
My lord,
authority
either the board
RPWD Act, he has issued a certificate. So far as what I'm trying to put.
I think one of the gentlemen is sitting there, he was a government leader. He knows better. Bakuna Medical issuing the disability certificate.
Yes, sir.
Government hospital issuing certificate randomly.
But so far as.
Then the court has to intervene. Will not go. Medical board has said not more than 40 will accept.
My lord said only one submission that your lordship I kindly accept. Because at page 54, just for a second, your lordship, I will bow down if I will heard your lordship. At page 54, the first medical board, it has given me 10% temporary. Your lordship has signatories who were the members of the board. One is the assistant professor of SCBH Katak. The second one is assistant professor Department of Orthopedics SCB MCH Katak. And the third one is the professional HOD. Now, against that, I have gone to appeal. The appellate board, they are consisting of the same members. The appellate board consisting of the same members who has given me 10% temporary. Can you see?
Yes, your lordship.
What's the first medical book?
At page 54, your lordship.
Not reading a page 54, that's why
I'm sorry.
Where in the?
You have insured the entire.
Yes, your lordship.
Where is the page 55? Yes. And where is the appellate?
That is at page number 57, your lordship. The serial number 4, Dr. Nirmal Chandra Mahapatra, Professor and HOD Ortho, SCD, MC, Conduct.
One member does not make, there are 5 members.
My lords.
So everybody has this uniform decision. One member does not mean, no.
So within the span
I
of,
just thought that the appellate board is also the same.
my lordship, within a span of 2 months, they have gone.
There are other orthopedic as well.
Yes, your lordship.
So
So within a span of 2 months, my disability from temporary became permanent. And one of the signatories, he was also the member. Even
signatory.
That Dr. Nirmal Chandra Mahapatra.
One will not do. There are 5 members. The other 4 may decide. Then it's a majority review which will go. And if all are one, I don't think so. There is any possibility.
But you're not sure.
One cannot judge his own cause. It's not an absolute rule.
My lords.
Not an
bow
absolute
down.
rule. Sorry, we can't. For that reason, we can't. There are other different members.
As cast a shadow of doubt as to how within a span of 2 months the members can differ from their own finding. And moreover, your lordship, in the
members don't use singularly use, don't use in plurality.
Singular member.
There is nothing because you must have. If he is enlightened more, then what? That you have not taken into consideration this. So why the system was introduced? Just to have a filtration. But still, by any means, you do not cross 40. Whatever.
I will not be
That's
appointed.
all.
At page.
These are all the existing problems. These are what one is the head. They are the department. They are
Which I'm trying to bring before your lordship is at page number 190. Just for a moment.
You doubt 1, 2, and 3.
My
You're very renowned.
I don't doubt your lordship. This is a person who is struggling to get one.
You know, Mr. What is their reputation in Orissa? You know.
But at page 119, your lordship, for a moment, the resolution on the basis of which, after receiving the certificate under the RPWD Act 116, 119, your lordship. Just for a second. 119. It's a resolution on the basis of which, suppose in the event, even if I get the appointment, I have to go for the physical verification. So what they are trying to say is 119 clause number 2.
Sir, unless you come under that particular physical disability quota, you cannot.
Do accept your no, I do accept.
So that is what say this the point that this person is there. And it says 21% no.
What I'm trying to impress your lordship is that at paragraph 2, serial number 3, the appointing authorities are under 20, your lordship. The appointing authorities shall verify the disability certificate before appointment to prevent false or fake claims and to ensure appointment of genuine person with disabilities. They may initiate action against such persons who attempts to commit fraud. So what I'm trying to say is, your lordship, that you can verify the genuineness of certificate which I have produced. Nobody is doubting that. Nobody is doubting that I have produced a fake certificate. It's my contention, your lordship, it may be accepted or not. but I'm trying to impress. At the serial number 3, the appointment.
I appreciate as a good counsel to have. I fully appreciate as a counsel, you have discharged very nicely, but I think the law is coming. The percentage of disability is an assessment of individual. It's not a political of any advocated calls for such kind of a law. It's whether the assessment which you have undertaken is correct or not. It's an error of judgment, nothing more than that. Fact. You know it very well, but I have asked you for thinking. Sometimes the bad cases are very. I have also argued that. got a circular notification of the university where.
No, my lord, I'll just explain on that point, my lord.
I relied on that, that's why I'm asking.
My lord, the university notification, which which the honorable single judge, the honorable court has referred to, that is only with respect to Rashtrabhasha Ratna. And so far as the Shastri is concerned, it is only a letter issued by the central government declaring it as equivalent, and there is no notification to that effect. And whether it is binding on the state government, your lordship may kindly see the paragraph 3.2 of that judgment. The judgment rendered by Honorable Justice Raman. That is not a notification, that is only a letter.
Whatever, sir, this institution, that is the Odisha Rashtrabhasha Parishad Puri, that's the reference is given.
But there is
And
no.
it says that if they have conferred or conducted the examination of Shastri, then it will be taken as the equivalent of BA.
But so far as that declaration of equivalency, that has to be either made by the state government or by the university. There is no such declaration. If your lordship will kindly have a glance to para
Why
3
the
point.
Shastri is included? If you do not recognize Shastri in any way, then why you have included a Shastri?
We have included is that with,
No.
along with the graduation. Your lordship may
I
kindly
have
have.
seen that everywhere with is so loosely.
But my lord may kindly have a glance to the para 3.2 of that judgment. Para 3.2. Para 3.2. For a moment, my lord.
I have a strong feeling.
Para 3.2. Your lordship.
Please kindly consider there are two positions. I just went through yesterday evening. If you come to the eligibility criteria, there are two.
Yes.
One, which includes a broader one, then in between there is an or. And then the second one you say that the graduation without an elective subject, but an optional subject as a Hindi and the honors. There we have said that we will not accept that graduation as the criteria. You have used the word and you must have a postgraduate degree, that is a MA in Hindi, and that too with a 50%. Now we have to then make that, why you make a distinction in between these two. If you look at your first category you have seen, where with everything. Then there is a or. Have you got?
Yes.
And then you read the second one.
Bachelor's degree with Hindi as one of the optional.
There in the first category as an elective subject. Here you have said optional.
Yes.
Plus then slash is honors.
Why we have said optional? Because along with that, we have made it mandatory to have MA in Hindi.
No, then the intention is what? The intention is what? That a person who does not have the Hindi subject as elective one, then in that event, he has to pass the MA in Hindi with 50% examination. But in the first, when you say he has an elective bachelor's degree as an elective subject, means the compulsory subject. Then in that event, if you have said or, that means you have experienced the or.
My lord, even
you have not included the MA.
My lord, even accepting, your lordship may kindly appreciate, my lord. Yesterday I tried to contact.
2023. And my brother has considered it and dissected everything that what has happened. I believe that if we have to go by the language which is used and the intention is very laudable. But you can't say one who has an elective subject, he need not have to prove anything. But if the Sastri is also there, and in that event, he will be regarded as a graduate in Hindi.
My lord, to that my only solution, my lord. Even accepting the contention of the petitioner that he has Sastri, and that is an alternate to the graduation, and that is also a graduation, my lord, then there has to be a declaration that Sastri is equivalent to BA. And there is no such declaration either by the state university or by the state government.
Then why you have incorporated it in your advertisement?
We have incorporated.
Now the question is, if there is no rule, there is no recognition, then why you have incorporated? Now you want, can you visualize this?
Yes.
A person, let us see. I understand what you want to see. A person who has obtained the graduate or they say the graduate degree, or who has the graduate degree, say in a science. But he also has a Sastri from that case. Then according to you, the Sastri is considered with no criteria, with, then in that event, he is eligible to offer his certificate.
Because my lord,
will it not bring some anomaly into the situation?
But that's admission means this one also has a report. 6 point. Diction WPC must be different. Or similar. I don't remember. I will verify. But division or similar?
Division, superman.
Number.
Verify con. It's fine.
Okay.
Okay.
So we want to do.
I'll get everything.
All these page.
Everything.
Then give it 6 point.
6.4.
Please look at it. It's a very interesting observations.
If possible, we get
Is OA also can be in the restrictions of that, which is referred to.
I'll get it, man. I'll get it, man.
But that time perhaps I didn't lay my hands on OA. OA.
We are fixing this matter on this one.
Right.
Right.
Item
We'll bring that. Yes.
27.
Next one.
Let the matter industry. Appointment of compromise.
What is that?
The advertisement was issued on 18/7/2023. The specific stipulation was that the candidate who will apply for the post has to submit the residential certificate issued within a period of 5 years from the date of advertisement. Admittedly, the private respondent applied for the post, but did not submit the certificate which was valid in the eye of law or as per the advertisement. The lawsuit will get at thereafter the selection was the petition was also the appellant was also one of the candidates. The lawsuit will get page 23, page 23, serial number 5. Haritri Mohanty. What's it? Column, the residence. Lots will get
I can name my ears here, but here there also.
But the residence are not valid. It has been written residence not valid. Despite that, she was selected. She was selected, and your lots will get at page 22. The selection list was prepared, and her name was there at serial number 4. And the observation is that verified residence certificate not valid. Go to page 22. Not valid. Still then she was selected. So challenging that selection, the present appellant approached this honorable court in the annual writ petition, that is WPC number 28402 of 2023. Well, this honorable court, basing on the revised guidelines of our appointment of Congommary worker is concerned, this honorable court was pleased to give her liberty to approach the ADM, who is the first appellate authority. And accordingly, the appellant preferred appeal, and that appeal was allowed. After hearing both the sides, the appeal was allowed on the ground that along with the application, since the residence certificate was not submitted, so her selection is bad. Challenging the said order of the first appellate authority, though the second appeal is provided under the same guideline, still she preferred the writ petition, that writ petition where the judgment is under challenge. Now, my lord, after being noticed in the writ petition, this appellant appeared and filed the counter. The counter, she took 3 grounds. First of all, the application along the the residence certificate was not submitted along with the application. Second appeal is to the
only point involved here is that if the advertisement indicates that the residential certificate has to be submitted along with the application, which must have a duration of 5 years. Then in the article it has to be done. It appears that you would know. The other side submitted. I think that you are not a victim here. You are some challenges is a point, other point.
Yes.
She submitted a certificate which was not a valid in eye of law in that sense. But she was found to be the best candidate for appointment, and she was given an appointment. She gave an undertaking that I will give a certificate, and a press certificate was given. That from a competent authority, which according to you cannot be done, because once the conditions are imposed, that conditions cannot be relaxed in any way. That's it. And the court has said that there is no timeline within which it has to be done.
Yes, sir.
So some flexibility is there, so there I cannot find any
The
legality.
guidelines, it has not been provided.
So let us hear the red petitioner, I mean the successful candidate. So you have to issue a notice about this. Give them a notice. Now the engagement has come, no difficult, let her continue, de-engage people to. But we can't stop. Anyhow.
The Lordship may observe that
Notice.
our appointment is subject to the final.
That is not, sir. The engagement is the restoration. And it's come. We'll see to it. What is on, what is the outcome? Is it public?
Very content number 46.
6. Returnable after 3 weeks.
Right.
Other side.
Item 28.
This is my writ appeal, military. Arising out of an order passed on 11th of April 2025, military. The Honorable Judge Millet has gone on to Millet set aside an award for invoking jurisdiction under Article 226.
What passed by the arbitral tribunal?
Yes, Millet.
Constituted statutory arbitral?
No, High Court. High Court of Constitution, Millet, under Section 11.
Okay, 26 lives.
Millet, if your Lordship sees, Millet, his Lordship was of the view, Millet, that deep industry was from the stage of Millet 34. But the Honorable Judge missed that deep industries gave a very small Millet place for a 227 after Section 37. Millet, it never said that 227 can substitute Section 34, Millet.
What?
Millet will kindly, Millet, I'll take your Lordship, kindly takes para 40, Millet, it will all.
No, I am looking at the impugned order.
Yes, Millet.
The impugned order.
Impugned order, Millet, it starts.
Okay, no, arbitration proceedings shall remain stayed. What is this done?
No, Millet, may I just point out, Millet?
Yeah.
He has set aside
The
the award.
impugned order is set aside, means the award is set aside by the
Yes,
court.
Millet. Yes, Millet.
Not under Section 34.
No, saying that the court has powers under 227, relying on deep industries, Millet.
Where is the deep industries that?
Well, it would be easier if, I'm showing it, Millet. Kindly comes to para 40 once, Millet.
40?
Of this judgment, Millet. Well, that
is a very small, it's a small judgment.
It is a very small judgment, Millet.
No.
Paragraph 40, Millet. Millet, it's the next order. I understood, Millet. I've understood, Millet. That was the. Millet, kindly comes to paragraph 40. If your Lordships are there, Millet, just above 40, just above that, Millet sees in deep industries, para 39. Millet, may I just read para 15 on which the learned judge. Well, I'm sorry, Millet.
Yes, para 39.
Para 39, Millet, quoting para 15. Given the aforesaid statutory provision and given the fact that 96 Act repealed 3 previous enactments in order that there be speedy disposal of all matters covered by it, here the statutory policy of the Act is that not only are time limits set down for disposal of the arbitral proceedings, then so the time limits have also been set down for Section 34. Equally in Indian opinion, that's not necessarily 16. Most significant of all is the non-option clause contained in Section 5, which states that notwithstanding anything contained in any other law in matters that arise under Part 1, no judicial officer shall intervene except where so provided in this part. Section 37 grants a constricted right of first appeal against certain judgments and others and no other. Further, statutory mandate also provides for one bite at the cherry and interdicts a second appeal. Now, Millet, kindly see, this is what the learned judge refers to. This being the case, there is no doubt whatsoever that if petitions were to be filed under Article 226 of the Constitution against orders passed in appeals, Millet kindly sees this. Under Section 37, the entire arbitral process would be derailed and would not come to a fruition for many years. At the same time, we cannot forget that article is a constitutional provision. So, Millet, then thereafter, in the underlying portion, Millet, the last sentence, under Article 227, again, judgments allowing or dismissing first appeals under Section 37 of the Act, yet the High Court will be extremely circumspect in interfering with the same. Now, quoting this, your lordship will kindly see para 40. It is therefore prudent for a judge not to exercise discretion to allow judicial interference beyond procedures established under the enactment. This power needs to be exercised in exceptional rarity and holds this to be the powers under which.
I think there are judgments, few days.
Yes, dear Dawson Mallet. He has looked into it. The Honorable Judge has looked into it. It's a complete code.
Yeah. Yes, yes.
Yes, he has referred to that.
Yes.
He has referred to that, but Mallet, for some reason, that 226 cannot bar an alternative remedy has overpowered his.
SBP has
Absolutely.
gone against that.
Absolutely.
SBP has said that against the order of the arbitral tribunal, no 226, no 227, nothing would be like.
As a matter of fact, with humility, I say, Mallet, the 226, 227, Mallet, what we say that alternative remedy is not a bar, but your lordship's restriction. In this kind of an act, Mallet, with humility, I say, special act and Mallet, a complete code.
No, Deep Industry says that since there is an interdict so far as the further second appeal against the section 37 order is concerned. So sometimes
yes. Absolute Mallet.
37 can be visualized that the court within the limited
Definitely, Mallet, that no one can stop.
But if it is an order of the arbitral tribunal, how can a 227 lie?
I thought his lordship was also a bit circumspect himself while passing the judgment, because at 63, the Honorable Judge says the impugned order stroke award is set aside.
The award can only be set aside under section
34.
These are the specific grounds which are given. Beyond that, it cannot. Associate builders or associate.
Everything that I trace every customer.
These are
They are all there. Mallet 34 has another impact, Mallet. Because of 34, Mallet, after 34, Mallet is 36. Now 34 subsection 1 gives the right that after 34 is complete, you have the right of execution. That, Mallet, cannot be taken away like this. Because if someone doesn't file a 34, Mallet, within the time period frame, then comes to a writ court and says, look, the writ court can take it up. Mallet, this is absolutely unheard of, Mallet.
Your Lordship, may I, Your Lordship, and submit? Your Lordship, I'm appearing for the respondent here. Your Lordship, the case over here is that the award, it's not an award. The writ
Well, that is the most important thing. This lordship quotes it in that way, but the order is not in the same spirit, if I may say so. Because
Your Lordship, am I audible?
Yes, you are audible and visible.
Yes, Your Lord. Your Lordship, this is an award. Basically, that impugn award 1/8/2022 has been passed as framing it as an award. Section 34 states that an award can be challenged. In the writ petition 32426 of 2022, what we have stated that it's not an award.
What?
The
reason what it is?
The reason being.
No, tell me, sir, when you say it is not an award, then what is the character of the?
Yes, Your Lordship. I'll
Please tell us what is this?
Yes, Your Lordship. This is arising out of an lease agreement.
I am asking you, sir, once an arbitral tribunal is constituted by a High Court under Section 11, then if any adjudication is made, please tell me what is the nature of that adjudication. Is it an award or it is something else? Let me know about it. Tell me.
Your Lordship, the adjudication done by the arbitrator is without jurisdiction. The reason
have you raised that objection under
Yes,
Section
Your Lordship.
16?
Yes, Your Lordship.
Have you
Yes,
raised?
Your Lordship.
Have you succeeded?
Wait, Lordship.
Have you succeeded?
May I submit, Your Lordship? Since the agreement was unstamped and unregistered.
Sir, I am again asking you, sir, then if it is an unstamped document, under a stamped document, if you do not raise an objection, and if the agreement has already been accepted, I understand where you are heading. You are going for by a SMST judgment, then per Garware, I think, what is that, Garware? Then three judgments of NN Global. One is three judge, then the five judge, then the seven judge. I understand. But none of the judgments have taken care of section.
That is one point,
30.
Your Lordship.
Please
That is one
look at
point, Your
section 36 of the Stamp Act.
No, that is one point, Your Lordship. That is one point, Your Lordship. The other point is, here in this case, both parties had already filed a civil suit. The civil suit is still pending. His civil suit, we have
Sir,
already participated.
I just wanted to learn that whether the writ court can set aside the arbitral award. I just wanted to
Your
learn.
Lordship.
Please,
Yes, Your Lordship,
please enlighten me on this.
And one more submission, Your Lordship. I have already filed a review petition stating, I have filed which is pending, Your Lordship, right now, and notices has been already issued.
Is there any deterrence in taking the appellate, excising the appellate jurisdiction as you have filed a review application?
My review application is only on the point that I cannot be relegated back to arbitration. The reason being both parties have already waived their arbitration.
I am conscious of the very latest judgment of the Supreme Court,
Section 8,
reported in 2025, Volume 5, where the Apex Court has said that the court, this 34 court or a 37 court, should not adopt a recourse of remitting the parties to the same arbitration by giving a remand. Order remand was deprecated.
Absolutely, Lordship. But here in this case,
So tell me the writ court can set aside the award?
if there is bad faith on one party,
Even if let us see it is perverse, can it? Tell me. Even if the order is perverse, tell me. Let me learn.
A copy should be given to me.
Given we are directing you to give a copy, but
yes, Your Lordship. I will satisfy Your Lordship why the writ court can have the jurisdiction to quash the award.
Absolutely. It will invite chaotic situations throughout the country. If this is accepted, it will create a chaotic situation. It will undermine section 34, 37. Then there will not be any scope.
Your Lordship.
Everybody, it reminds me of Justice Krishna Iyer's famous observation in
Your Lordship, one more point.
Clever draftsmanship.
It will undermine
Creating an illusory
section
cause of
8
action
application.
and then going to the jurisdiction. What is that? Andam or what is I just forgot.
1977 Supreme Court 2412.
Your Lordship, it will undermine section 8.
That is our favorite.
No, it's creating an illusory cause of action by a clever draftsmanship.
Your Lordship, it will undermine section 8.
Whatever, I can't pronounce. My brother will be able to pronounce more clearly.
Your Lordship, may I submit, it will undermine section 8. Section 8 is as per section 5.
Section 8, sir, section 8 of the Arbitration Act talks about the judicial officer.
Yes, Your Lordship.
There is a distinction. Please consider there is a distinction under the Arbitration Act between a judicial officer and the court. The court is defined under section 2E.
2E.
What does it mean?
Yes, Your Lordship.
And section 34 is also defined the court. Section 37 also defines the court. And section 42 will also come into play. What is the meaning of the court? Section 8 is relatable, where the parties primacy is also there. They can waive their right to go to arbitration.
That is my
point. Can be done.
That is my point, Your Lordship.
That's not point. Then the writ court. Forget about what is there. You go take this plea in a civil suit. Telling me that the arbitral tribunal can be set aside in a writ proceedings. Let me learn. Give me one judgment.
I will show
one judgment. I will be happy. I will be happy to accept it.
Where even 9-bench judgment has stated, if the statute has been flouted and an order has been passed, be it so an arbitral tribunal, then this court under 226 and 227 can quash that order.
Yeah, sir, then SBP has to be read.
SBP is only
Please
your
read
lordship
that
pertaining
five
to
judge
section
bench
11, your
decision.
lordship.
SBP
SBP
versus
is only
Patel
pertaining
Engineering
to
five
section
bench decision. Read that.
SPB is only pertaining to section 11, your lordship.
Sir, not section 11, sir. There is an observation.
Seven
In
That's
one
an observation,
paragraph,
but that is
if
an
I
observation
correctly
only
remember,
pertaining to
must be
section.
34 or 35.
Or your lordship, at least my review petition is also lying.
Sorry, there
And
it
has
says
been issued
no
notice-
226, 227 application should be entertained by the court against the order of the arbitral tribunal. Do you have
After that,
copy of
when
this,
construction has stated, if there is a bad faith.
I think
then-
2005 volume 8 SCC.
Yes, your lordship.
Give me that SVP judgment. Do you have?
Yes, yes, sir.
Give that paragraph.
Sir,
What?
SBT is
Have you got this?
No.
But SBP, as a matter of fact, his lordship has also quoted, I just pointed out.
But that paragraph has been quoted.
That paragraph, Madam.
Where is that?
Well, at internal page 13, I'll just point out, Madam.
Where?
What is that? Read the page, 13.
No. In the impugned judgment,
Well, it is.
SBP is quoted. I found it is there, but that paragraph.
Page 13 of the written.
Please, that paragraph, yes.
54 and
Come to page, the paragraph 17 of the position. No, this is not SBP. Sorry.
SBP, page 30. 1 ground number D.
Yes, sorry, paragraph 44.
44.
This is, brother, look
44
at
and
it.
40.
Look at it. Says, clearly says that no 226, 227 is the order of the.
And followed subsequently also by.
But there are certain judgments which has been passed after 2005, your lordship.
Are the courts bound by a larger bench or a constitution bench decision
Absolutely,
or a quorum decision?
But the facts are different. What I am agitating, your lordship may issue at
What
least.
is the award is set aside?
Well, the award is set aside and then again remanded after it is stamped.
Your lordship, the award is not, the agreement has been impounded.
The portion of the order by which the remand is
Yes,
made,
madam.
we are staying it, serve the copy. A piquant situation has arisen in the instant case
section 8 has already reached finality. So hence arbitration
Sir,
cannot.
come and convince us on the next week. Let us see. We will have a very, very meaningful discussion or
At least, Your
exchange
Lordship,
of
at least 2
our
weeks.
views. Don't
At
worry.
least give me-
Come.
At least give me 2 weeks, Your Lordship, so that at least I'll
Yes,
be prepared.
any day you suggest. Any day you suggest. When you
Your
can
Lordship,
prepare
2
yourself
weeks
fully.
after 2 weeks, any day, Your Lordship.
When you feel that you will be prepared fully, tell me
Yes,
that.
sir.
Tell me the date.
28th, Your Lordship.
28th, no difficulty. Fix on 28th.
Fine.
Your Lordship. Obliged, Your Lordship.
Come. Item number 29.
Privilege 212 days. No, exactly, I'm just saying. The order passed. The order passed.
He's conceding to help you.
That order was passed on 2nd July to 2024.
What do you say? So we condone it 200, you are conceding.
No, my lord, I'm just objecting. They have already failed to.
Let them propose, then you object. They have not proposed.
I have already filed my objection.
They are done to argue, sir.
Yes, sir.
Two eyes are there before your lordship in this orders matter. One IA has become infructuous, which was filed by my learned friend, seeking for its reinstatement by 30th of April. So it has become infructuous. That IA at flag D. The other one,
This is
flag D,
to reinstate.
Reinstate by 30th of April.
So that has become.
That has become infructuous. The other IA, wherein we have played for condemnation of failure.
2107. After perusal.
Question of law, the lordship will find official problems. Thereafter, we have taken note of the Supreme Court judgment, wherein it is
Shivraj Singh, everywhere it is quoted, but there has been a lot of
developments.
And
there are subsequent judgments also.
subsequent.
But only thing, my lord, also that judgment has not been reflected here. Another judgment your lordship have rendered, where substantial question of law is involved. Your lordships are lenient. while condoning. Here, a substantial question of law is involved. Why I am saying, my lord? Because
That is not your ground.
sorry, ma'am.
That is not your ground.
The question of law, possibly I can agitate. Question of law. What is the substantial question of law in the main case, my lord? Disengage has been challenged. That was quashed, but at the same time, regularization order was passed. In a single petition, disengage was.
What was their prayer?
Prayer was challenging the disengagement order. So at best,
no prayer for the
regulation. One petition, two prayers cannot be there.
No. I have multiple prayers. Why it can't be that? If they are consequential.
Consequential, yes, I understand.
So,
if it is consequential, yes,
so
it can be.
reinstatement and then regularization is a consequential.
The regularization is
I'm not very technical one.
some judgments are there. Today I am not arguing that judgment, but some judgments are there. You are also correct. If it is not arising out of that main prayer, then two distinct
It can
prayers.
attract only the court fees to be paid for an independent prayer.
The question of maintenance, I am saying. Here in our High Court,
It's also notification of two proceedings. He could have done it.
this is the only thing I can submit. 213 days, admittedly, there is delay. Official paraphernalia, this has been.
If we give on merit.
No, my lord, that's 213 days. I have the order passed in the OA number, WPC OA number.
Defeat him on merit.
Merit is already there, my lord. This order has para 16, page 16. Lots of the passed by the single judge that can view of such material irregularity, which is apparent the face of the impugn order. This court is inclined to pass the same. While passing the same, this court direct opposition to reinstate the petitioner in his service and consider his case for regularization as directed by the tribunal in its order under Annex 5. Opposite party 2 is directed to issue an order to reinstatement within the period of 3 weeks from the date of receipt of this order and take a final decision with regard to regularization of the service of the petitioner in terms of the order passed by the tribunal within a further period of 3 months. However, it is observed that this instrument and regularization service of petitioner shall be subject to final outcome of the vigilance case, in which it is fairly admitted by the law counsel for the petitioner to charge sheet has already been filed with the writ petition stand disposed. Thereafter, that order passed on 2nd July 2024. Thereafter, the respondent filed a contempt case with number 7313/2024, and upon service thereafter, the 1 month that court already. So order 27/1/2025, the 7313/2024, to consider the fact and circumstances of the case, and upon hearing law counsel for the practice, this contempt petition is disposed of by granting 1 month further time to opposite party to contender to comply with the order passed on 2nd July 2024. However, if the order is not complied within the extended time, it will be held as a deliberate violation of this honorable court. Thereafter, again, I have filed the second contempt. That is after second contempt 1206/2024, they prefer. Thereafter, the government preferred to file a writ appeal on 1st March 2025. That is delay of 212 days.
The lordship comes to para 3 of the improved judgment. There the lordship will get the prayer. What was the prayer in the main case? Para 3 of the improved judgment is available at page 11. Petitioner has filed the present petition internally telling the order goes on so far for the calculation but no 200. But this order the prisoner was disengaged from service. Disengagement order was challenged. But while setting aside that order for regularization has been passed.
Section clause.
Funding is very cryptic.
In the IA.
What does the record shows? You are not requested anything from the record.
Very cryptic.
I can't develop it right now, but actually when following the official process, these things are happening. But possibly I will be in a position to convince your lordship that substantial question of law is involved there. If your lordship accepts, then it will be hard otherwise. Because for the purpose of regularization, several other circulars are required to be placed. While considering the case of disengagement, those circulars are not there before the court. For regulation, the lordship knows from 86 onwards.
It is not there. You did not produce it.
Who didn't get an opportunity, my lord?
Why?
Because the case was for disengagement. He was challenging that only. Over there, notice was received. Notice was issued to us. We replied on the question of disengagement. About the question of regularization, we didn't get an opportunity.
213 days your lordship is sufficient for enough time to the disengagement was for a past cause.
The disengagement, that was in another original direction. Violating your lordship's direction, order of disengagement was there. That was challenging the subsequent case. While setting aside the disengagement order, the Honorable Single Judge passed an order for regularization. Reinstatement passed, thereafter regularization.
Thereafter,
But for regularization, your lordship knows several circulars are required to be considered.
Directed to regularize his service.
I
That is
don't
the
dispute
tribunal
that,
order.
but actually, there is no
Tribunal
dispute.
order that I am not going for the complaint.
Actually, I don't dispute anything.
What tribunal? What tribunal order?
Initially, it was before the tribunal. After closure of tribunal,
2018.
initially it was before the Honorable Tribunal, State Administrative Tribunal.
This order para 5.
Para 5. My lord. Even though notice of the writ petition has been issued on 18.
Means the single bench. Several opportunity was given to file the complaint.
One opportunity, order number 2.
No, 2006, 2008.
Yes.
Is pending, sir.
I am conscious of that. This
So-
order number 2 only.
So, why you did not, and the judgment was delivered later on.
Possibly I could
That
place
is
it properly.
2024 means 6 years after.
Yes. There is no, I cannot dispute that. Possibly I couldn't express properly. Even if had we filed a counter, that would have been as against the order of disengagement, not about the regularization. The matter related to disengagement only.
No, that's
Had I got an opportunity to
sir. There are 5. Sir.
Yes, I am reading that, my lord. Even though notice of the writ petition has been issued since 28/6/2018, but no counter affidavit has been filed as on date. But basing on the materials available on record, the ASC contended that since while considering the claim of the petitioner in terms of the order passed by the tribunal under Section 5, it was found that the petitioner has been implicated in a vigilance case, that is Cartel PS case number so and so, under an accepted, it is Part number 2, so it proper to discharge the petitioner instead of considering the account petition for regularization in terms of the order by the tribunal. That was
Sir, We have brief of way.
Away.
Repetition, do you have?
Converted it.
Sir, he has made a twin prayer. What you are saying is factually does not appear to be a correct one. He has prayed twin reliefs.
That's what I said. Twin relief, he cannot
Twin
make any
relief, one
pains.
relating to the content of the disengagement order, and the second one is the regularization from the date of the initial appointment. Now, the two prayers, according to you, are independent.
Yes.
So the writ means the tribunal application is liable to fail. These are all the, I would say, procedural or ministerial error does not really wipe out the substantial.
Even not considering that point, my lord, after the said petition was disposed of, direction was that was first written. This is second one. First one, he has challenged that order that was disposed of. This honorable court directed the authority concerned to reinstate him. Thereafter, the second writ application was filed since he was not reinstated but disengaged. Initially, two petitions are there.
No, I understand, sir. Whatever be, in the second writ petition, in which this improved order is passed, we find there are two reliefs. One is setting aside the order of disengagement and regularization from the initial date of enforcement.
That is not.
So this is what, according to you, these two prayers cannot go together.
Together, our judgment, our High Court judgments are there.
So let us see, there is one Supreme Court judgment which I know about it.
Consequential, it is permissible.
No, that is under section 34 of the Specific Relief Act. Section 34 that you will have to make the prayer. If you omit any of the prayer, then the suit is liable to fail. But this says that any consequential, if it is there, if you have not prayed, then these are the two independent prayers. That permissible. Because one and two both are interrelated to each.
So
these are interrelated.
May I propose one thing, my lord? Your lordship rendered that judgment condoning the delay. Your lordship, on the merit of the case.
That is object. Unnecessary delay. Harassing 2 years.
Actually, I don't dispute those things.
2 years, yes, also 32 years ad hoc basis.
I don't dispute those things.
The case was already filed.
Item number 30.
30.
Yes.
Item 30, I 2167. There's a delay of 131 days.
Thank you, sir.
Notice has come.
Notice.
Item 31.
How many days delay? It's about 70 days delay.
This is for the, when you serve the copy of the same.
Here, after so much, I should solve.
Please, sir.
In course of days.
Yes. Serving a copy, we are keeping this matter in the next week. We accept the copy. Yes. Service of the copy of initial
Item 32.
Delay 9 days on delay.
Thank you, sir. Have you given a copy?
Sorry. Copy number.
Please give the
Application to IA not served. IA copy not served.
Not sir.
Not served.
Please serve the copy.
Sir,
Everything is ready.
Oh, they go in from the education copy not served, that's why. Have you received the counter?
Yes, my lord, the receipt counter result has been filed. Things have been completed. Thank you, and Mr. Mishra, Mr. Tripathi was appearing in that case.
It's not on the board.
Have you served the copy of the rejoinder to him? Yes.
Item 34.
Before I pray, maybe taken up next week. 34. 34 will be taken up.
Why?
Because I have not gone through
You have pulled up all the briefs.
that brief I have gone through. Yes.
I file a short note. I file short note submission with short briefing the short just I serving to my friend.
They are not brought. The brief is not there.
Oh, sorry.
You are searching for.
So it tomorrow next page a lot. I
Item 35.
Item 35, first matter, I am appearing for the petitioner. But in this case, but the proviso appended to Rule 15 of the Orissa Elementary Education Cadre Service Rule 1999, Amendment Rule of 1999, and 11 is under challenge. Where under?
Why this you are challenging?
Yes, madam. Virus of the rule is under challenge.
What virus?
Virus. The rule.
Virus. Yes. So according to you, it contains a virus.
Virus. Well, solely on the ground that it is suffers from legislative incompetency, and second, well, it also
Why they do not have the power under Article 309 or the
yes,
162 of the Constitution.
Madam, because the RCFC Act, which came into force with effect from 1/4/2010, clearly mandated that in case of relaxation of qualification, it is the central government to bring relaxation on the request of the state government and by way of a notification. But here what has happened, this central government by way of amending the RCFC Act in the year
What is RCFC?
right to free and compulsory education act in short
to the children.
Yes,
See
madam.
that? So abbreviated form is
Madam.
2009.
Madam, to save the time,
We
madam.
call it a right to education.
Madam, RT Act, madam.
REA.
Madam.
Yes, a right to education. Yes. Then
Under the said act, madam, the amendment was made in the year 2017, mandating that the qualification as prescribed by the NCT, who is the prescribed authority, is required to be acquired by teachers in position by 4 years, which will be given effect to from 2015 to up to 31st March 2019. By 31st March 2019, initially it was 5 years relaxation, 4 years it was added. By the end of 31st March 2019, each teacher in position is required to acquire the qualification prescribed. Qualification is for the class 1 to 5, higher secondary course or training plus OTT pass. And in respect of upper primary 6th and 7th and 8th up to 8th, that the qualification is BA academic qualification, graduation plus training qualification plus also OTT pass. Well, what happened? Why this amendment is governing the field, state government in exercise of under power proviso to 309, Article 309, brought an amendment to the Orissa Elementary Cadre Service Condition Rules of 1997, clearly incorporating that teachers, those who are appointed prior to 2011, 11 to 2011, they are not required to pass the OTT manner. And that exemption, by using the word exempted, they are exempted from acquiring the OTT qualification. Such a exemption provision has been brought by way of in exercise under proviso to 309 is contrary to that mandate of the RCFC Act. And also the rules which are framed under
the point which struck in my mind is, then can you vary the condition of service after the service has commenced? If the service condition at the time of an appointment postulates that these are the things which is there, can you vary the service conditions subsequently?
But my humble submission is, even the RT Act has taken care of it.
Can it be varied?
But the Act has already taken care of it. 5 years relaxation was initially granted when it was enacted. And that was extended plus 4 years. That is by 31st March 2019. The Act said so, And the rules framed under the RT Act in 2010, my lord, clear provisions are there. In case of hardship, then state government is to, or union territory state government is to make an approach the central government for relaxation of any of the qualification if the teachers have not acquired that. On their request, it was extended twice, and finally it was extended to 31st March 2019. And the procedure that is under Rule 17, 18 and 19, that makes it clear upon the request of the state government, central government is to examine it and relax manner. Relaxation word is there, not the exemption which bears in the impugned order, impugned portions of the exemption, the amendment.
What is the distinction or difference between a relaxation and the exemption?
Exemption is for all time to come, exempted from the particular qualification.
Relaxation, according to you, is a one-time measure.
Yes, madam. For a particular period, they have to acquire within that period. They have to acquire the minimum qualification under the RT Act.
It be said to be an extension of time. Why?
Yes, extension of time. Relaxation is an extension of time.
It will be termed as a relaxation.
But the RT Act used consciously in its wisdom, the legislature has used while enacting the RT Act the word relaxation. No exemption word is used there.
That is why I'm also trying, because there are some other judgments are hovering in my mind on relaxation.
But
that is what I'm asking. That what is the intention? You will find the series of lot of judgments, even of a Supreme Court has come, where the authority, while making a recruitment to a particular field, have earmarked the particular age, and the power of relaxation of the age is also given. So, if it is the power to relax the age barrier is also provided, that means that if they have said the candidate must be between the age of say 18 to 25, then the power of relaxation is given. The authority has said no, from 25, 30 up to 30 to care. Given. So this can't be said to be of a very temporary in nature to operate, because it gives a relaxation to those who are entitled for all time to come. Later on, he cannot say that since you were overaged, relaxation has no meaning. There it says that it's a relaxation for the time being given to us. Exemption is perennial in nature.
Yes, my lord. Exemption is perennial.
Perennial in nature.
My lord.
Whoever
irrespective
of any criteria, prior or later, they are exempted. This is not a case. This is really an exemption, what we are saying. It is really a relaxation which has to be construed. Nomenclature does not decide it. The substance has to be looked into. You are aware of those line of judgment? Nomenclature of an application or a nomenclature of anything is not a determinant factor. The court must look into the substance and find out what is the real intention. So relaxation is permissible. So we have to look at the provision whether it is a relaxation or an exemption.
Here they have, if your lordship will, it is exemption. Clearly, it is exemption.
For all candidates.
No, my lord, it is for the teachers, those who are appointed prior to 11 February.
Really relaxation. Yes. But any teacher after that, he has to pass.
Yes.
My humble submission before lordship. Here, your lordship will find the Act makes a provision.
When it came.
Let's the provision, man.
I think that 15 or 13.
2009 came into force with effect from 1st April 2010.
Anybody who is appointed after 2009, if there is a NCT guidelines, there is a mandate, they have to follow it. They cannot be, they go for an exemption, even a relaxation, they have to.
But the apex court decision is there.
the apex court has held that the NCT guidelines should be followed in the throughout India.
We know.
Yes, that's why this prescribed.
No, the prescribed criteria
Yes.
for NCT.
Yes.
It is to be followed.
So that is a mandatory. OTT.
This is
mandatory.
We are not concerned with this. We are now concerned with the bias.
My humble submission, this situation arose in different states, and even in the state of Bihar, rendered the judgment no OTT is compulsory. They have to pass. That was challenged before the Honorable Apex Court. That judgment was confirmed.
It is one thing. But to held a particular law, ultra virus is something else. Please consider. You are arguing an ultra virus. You should know that when the court can declare a legislative action of the
Ultra virus.
of the
First of all,
of the legislative authority. There are 4 or 5 principles.
Yes, madam. E. Krishnamurthy judgment, my lord, and other judgment also recently.
The judgments are very, very simple. Last judgment which I know about is Justice D.Y. Chandrachud's judgment.
Gaurav Kumar, madam. In case of Advocates Act, it was laid down, madam.
Yeah, it is lordship doesn't know. That was the decision. And that first thing is, it is against the constitution provision, any of the constitutional provision.
Yes, madam.
It is against or infringing the fundamental rights of the parties, which cannot be undermined in the very scope. And the third one is that if there is no power which is conferred upon the legislative authorities, or it does not come within the state list of the 7th schedule of the Constitution, yet the law is made.
Yes,
then it is beyond the competence of the state to make a law.
Yes, madam.
The fourth one is the law has its operation beyond the territorial boundaries of the state. Then the law can also be declared as, I'm talking about the state. Then in case of a subordinate legislation, it is against the parent, any provision of
Yes,
the
ma'am.
parent act.
Yes, ma'am. That is
Or
clear.
in absence of any rule-making power, the rules are made. These are the
Basic ingredient,
broad
madam.
principles on which, and then the question of reasonability, test of reasonability, all these things may also come. These are the
My humble submission is, all those criteria are available in this case. First of all, the
Not even a single is spared.
Not
Not even a single instance is spared.
If I will place, my lord,
Incidence is spared in your case. Yeah, all the grounds are there.
First ground of
There at least one ground. Don't take all the ground. Yes, what is this?
Alert in second sub-item, I have filed an application for intervention. There is a notion that I am filing it. Also be consider it and allow that. I am the beneficiary of the amendment.
The improved provisions.
Then you are a necessary party.
I am in read petition number 21.
Who is there in this, in your writ, where you have filed an application?
Yes, I am for the second sub-item. Second sub-item. Because then I. Yes.
Yeah, necessary party.
Yes, sir. They have given copy.
They are a necessary party because every decision would affect their rights. They are the beneficiaries under that particular
amendment. Here the sum.
They are entitled to be treated as a party. Or the right of hearing is there.
Here, in this case, there are a batch of non-OTT candidates, underqualified candidate intervened. They have been entertained. They have been allowed to file their response, and we have also been allowed to file our reply. That we have done. The matter was heard in length. It was reserved for judgment. Again, it was released, madam. But because of
another division bench. The earlier one.
This is retired.
Automatically it goes.
Yes, madam. 17 January 2025. Madam,
Which I
IS 75575.
WA number?
WA 17780.
Please, well,
Yes, yes.
again, bear it.
If
Not so. If right permission, in item 35, this was matter WPC number 35836 of 2023. It is not rated this issue, Your Worship. It is not rated this issue, it has to be listed.
358.
35836 of 2023. State is there.
I'm there.
State is there.
I have not gone through. I rely on the statement.
If it come on that day, you just renew.
Item 36.
With your lordship's permission, Millards, I beg to appear virtually, Millards, in this matter, Millards. This is a tender matter, Millards. With your lordship's permission, may I proceed, Millards, in this matter? Petitioner, Millards, may I proceed, Millards? Petitioner, Millards, is the successful, successful bidder, Millards, of the of a sand bed quarry called Lungei. Millards, the agreement of that quarry, Millards, that was executed on 3/12/2019. If Millards will kindly take that agreement, which is
Where is the letter which you have challenged, the Annexure 5?
yes. Now that is a letter where your lordship will see at page 51. What I have been communicated is that you cannot operate the mines, the quarry, during 7 a.m. to 9 p.m. And that is what, if I may kindly read, Millards.
Correct.
In inviting a reference to the subject cited above.
No, I have seen there is an order already passed.
That is, in fact, that is my humble submission, Millards, is there is no such order that has been passed.
Means there is no order of 6/2/2024.
No, Millards. That judgment, Millards, a copy of that, Millards, would be in your lordship's file, Millards. In the case of Prashant Das, if your lordship will take that judgment of 6/2/24 in writ petition 6375 of 2023.
Where is that?
Millards, I had given a judgment, copy of that judgment to your lordship. It must be in the record, reflecting in the record, Millards.
Is there?
What has been reflected in that letter, Millards, is only a submission made by the learned advocate general. It was not a direction of the honorable court.
But is amicus good?
Yes, my learned senior, Mr. Darti, is the
His father is in hospital, so.
Millards, that
In this matter, is there?
he's been made an amicus curiae, Millards, because he was the conducting lawyer in that Prashant Das judgment, that 6/2/24 judgment.
Where is that order? I just wanted to, or a judgment, I wanted to look at 6/2/2024.
Millards, if your lordship will call it tomorrow, Millards, I'll then give once
Do
again.
you have the copy with you, all of you who's appearing?
Millards, I had given a copy. Millards, would it, may I screen share it, Millards?
Yes.
May I screen share it, Millards? Share it on screen, Millards?
Yes.
Yes, yes, allowed. The screen sharing is not being.
No. How can he?
You can allow. Yeah,
Now you'll have to give them
the access is given.
the access.
Yes, it is given.
Otherwise-
It's forwarded.
Don't you have the copy of that order?
It shows disabled. The screen sharing is disabled by attendee.
Anyhow, come. Keep it day after tomorrow. Man. Keep it
Man.
day after tomorrow. Yes.
Milats, may I pray, Milats, it may retain its position on the list, Milats?
Yes.
Item,
Yes.
Grateful.
37.
item 37.
Item number 37.
39 that uncertainty was made.
I am going serially. 37 is arguing. Don't worry.
Let item 37, your worship. This is related to blocking of portal registration.
Oh.
The period of blocking as per the guidelines.
Yes, we directed yesterday this matter was taken up.
No, it's not.
That you could not upload.
No,
this is not a case.
This is another case, which we are not uploaded. The guidelines state, annex the guideline, this minimum period is blocking 180 days. After 180 days, the contractor is required to file an application for unblocking of the portal registration, and the tender authority shall recommend for unblocking. Here, below, I flag D, Miller. But in due guideline, I file application by Treasury Chal and Miller. They have
take up this matter. They are.
Why? You want to take instruction?
No, give some preparation.
File is not period 180.
Oh, file is not available.
Yeah.
It does not carry a file. What can be done?
Yes.
Day after tomorrow you come.
Only humble submission.
Day after.
No place.
Item 38.
38 is 38.
On behalf of Sukandala, is other day on.
Next week or 2 weeks?
Next week.
Next week. His father is hospitalized. What?
I am not.
39.
They were staying near this Surya junction, the area adjacent to it. And the entire area, because of this rainy season, because of the lack of sewage system and the drainage, is waterlogged and there is no drinking water. And the power supply has become irregular and nobody is taking because it's not part of CMC. CMC is nowhere connected.
So what is this? Whose part? Now, who takes care? It's No, it's under the municipal corporation or a municipality or what? A panchayat, what?
The Gram Panchayat. Now it's part of the Gram Panchayat.
So there is a Panchayat Act of the state. There must be a Panchayat Act of the state.
Yes, Gram Panchayat.
So if the
city has taken over the entire area. No, the city has taken over.
Who?
City.
Development authority.
Oh,
that
just across Netai Setu on that side. People must have gone to that side. And now it is totally waterlogged and no drinking water is being provided. And Jolossi has interfered. On the last order, Jolossi has passed directly to state to file an instruction.
Yes. What are you doing? You drain out the water immediately. You can't keep it
whatever the reply they have filed is regarding 2020-21 the projects and thereafter nothing has been done.
Yeah.
So they are saying that we have attended this, we have done this work, but all were till 2021.
All things are admitted, we have filed a affidavit.
Sir, now says that because of the rainy season, now the rains are coming.
In the meantime, it is taken over by CDA.
TDA has been noticed. Somebody is appearing.
Yes, notice.
Where?
Notice.
Who is representing the CDA?
That was Mahapatra Senior Counsel, his office.
Yes.
Advocates are there, but senior counsel.
So there cannot be a water logging for all time to come. You can't. And the drinking water is the essential.
What has happened is in the last 3-4 years, most of the development has come after this COVID period. So after that, nothing has been done. And most of the areas, there is absolutely zero sewerage system.
Then how these foul waters and everything is
getting logged wherever the open spaces are
so
there.
It's not a hygiene. It's not hygienic for everything.
Sir, council, you have been mentioning.
Yes.
But have you intimated Mr. Dayananda Mahapatra?
See, the name is there, my lord.
He usually appears for CDA.
My lord,
You inform him, we are keeping this matter tomorrow.
Tomorrow.
You just inform him and we'll take up this matter at 4.
At 4.
Any panel counsel, you just take it. In his presence.
The serious issues are raised in the instrument.
Another
More than 500 members are there.
What, more than 500?
His house is inundated with knee-deep water. We all are taking Mr. Sharma's house.
That's an item of this. Tomorrow, because.
Let us see. We'll reach.
Spilling over every week.
Yes.
And miss the past.